Okay, the meeting is live streamed.
Elizabeth, your camera keeps moving like it's moving.
Okay.
It's,
Um,
it's like a shaking. I noticed that yesterday. All right. So you are the host now. I am gonna leave.
okay, you're posting?
Yes. Bye.
Okay, thank you, Miss Anna. Okay. Good morning, Mr. Lee. How are you?
Good morning, Judge. How are you?
I am. I'm here. And hopefully we're not going to have the glitches that we had yesterday.
Yes, ma'am.
It was explained to me that it was not internal. That does not give me much comfort.
I hear you.
Did we do okay on providing breaks and
Yes, ma'am.
not wearing you out? I don't.
Yes, ma'am.
You just need to tell me.
Yes, ma'am. I will do that.
I'll listen. Absolutely. Great. Well, we are just going to have to work around the commissioners being at their open meeting and then coming back to ask questions after the conclusion of that. And I'm not real sure of how long it's going to be. So that's kind of why we're in a less than definitive position.
That's all right, Judge. I serve at your pleasure, so don't worry about it.
Well, thanks so much for sending out the draft. That was very expeditious.
Yes, ma'am.
Well, I guess I'll start letting them in. And
all right, I'm gonna mute and step out for a moment.
All right, sir. Thank you. Good morning.
Good morning, Madam Hearing Examiner. How are you today?
Well, I'm hoping I don't have computer glitches today.
Yeah. I didn't get to tell you, but I had one yesterday also. You might have noticed that you had to let me back in again on my phone, and then I had to switch locations. They took out my internet and I had to go to another location. I appreciate the accommodation.
Well, I was informed by our IT department that it was not an internal issue. And that does not give me much comfort.
No, it does not.
So, technology, yay.
Right.
But, so you probably got a notification. We're live streaming already, and, we'll begin here, in about 10 minutes. So if you want to,
I
run
have
out and get that cup of coffee or,
I have one pre-hearing issue to bring up, Madam. Hearing.
okay,
I was just informed this morning that COG's expert, Steve Barron, has a medical issue.
okay,
It will now make him unavailable 2 mornings of next week, Monday and
Okay.
Tuesday mornings, but he is available all other times.
okay.
So it's just the 26th and the 27th of the morning, 9 to noon.
Very well.
I appreciate the accommodation. Thank you.
Thank you, sir.
Madam Hearing Examiner, this is Josh Smith on behalf of the Sierra Club. I had a similar update that I wanted to let you know about.
Okay,
We had mistakenly represented that Ms. Glick would be out of town starting on Friday. It
yes,
turns out she will be available Friday if need be, but
okay.
she will be out of the country starting next week. So hopefully we can get her on sometime in the next
This week.
few days.
Okay, very well. Thank you.
Thank you.
Okay. Good morning to everyone.
Good morning.
Just as an update, I have, number one, everybody should have gotten the notification. We are already live streaming on day 2 of our hearing. And in speaking with IT, my understanding is that the difficulties we had yesterday were not internal ones, which doesn't give me a whole lot of comfort, but hopefully our service provider has gotten things taken care of, and we won't experience the same difficulties as we did yesterday. And then I've gotten an update this morning regarding the availability of a couple of witnesses. I do not believe that it necessarily affects the parties, i.e. Ms. Lynch's examination time, but I was informed that COGS witness, Mr. Barron, is not available Monday or Tuesday mornings. He's available after 12 on those days. And then an update from Sierra Club that Ms. Glick is available Friday also, but not next week. And she did not invite us to go out of the country. So guess we'll just have to stay here and do the rest of our hearing if we go into next week. And so does anyone else have anything procedural that we need to address before we begin with SPS's next witness?
Your Honor, I have a couple of witness updates also, depending on how quickly we move.
Okay.
Dane Watson, if he's needed to testify, is available on Friday, but not today or tomorrow. Actually, yes, that's correct. He's available Friday. And Jeff Kopp, if he's needed to testify, is available Thursday morning.
Okay.
And that was it for now. So we may need to shift people around just depending on who's called and how we need to adjust.
Very well.
Madam Hearing Examiner?
Sounds like Mr. Getko.
That's correct.
Yes, sir.
Mr. Woolridge is just so you know the circumstances is his daughter is getting married on Saturday, so he's been very kind to be accommodating us, and he is still available Friday, but it would be absolutely ideal if he is called if we do Friday morning. He's
Okay.
He's out of state for a wedding, and it's his daughter, and that's the best time for him. So.
Okay.
I've heard so many excuses before, Mr. Gedko, but I don't know.
Well, we can just all hope it's a beautiful marriage.
Absolutely. And that, that he gets everything that he needs to take care of done, and participate, in the hearing. Okay. Anything else procedural?
Your Honor. Yes, Your Honor. Oh, go ahead.
Mr.
Nick
McMillan?
Stoffel for the NMLCG.
Oh.
Sounds like Michael and I are just talking at the same time.
You
Just
are.
a couple updates on our witnesses. So Mr. Higgins is unavailable after 4:30 today. In the unlikely event we actually got to him today, and then he has a conflict tomorrow afternoon after 3.
Now, who is this?
Friday. Mr. Higgins.
Mr. Higgins is not available.
Today
Tell me
after
again.
4:30
Okay.
or tomorrow after 3. He's available on Friday. And then for Mr. Bieber, he's unavailable tomorrow after 2.
Okay.
Thank you.
All right. Mr. McMillan?
Yes, Your Honor. I may be having an associate of mine appear for OPL tomorrow. Would you like us to file a written notice of appearance, or would it be sufficient for him to appear orally at the hearing?
Is it somebody who's licensed in New Mexico?
Yes, he is licensed in New Mexico.
Not necessary. Who would you?
Who
would this be?
His name is Christian Rice. Is the likely person. And the reason I ask is because he has not been on the written pleadings in this case yet. If it ends up being someone who is on the written pleadings, then I can, then I figured that that's not an issue.
Okay.
Is that RICE?
RICE, yes, and Christian.
Thank you.
Okay. And no, as long as he's familiar with the proceeding and familiar with the commission rules, and he's friendly, that would be fine, Mr. McMillan.
He's very friendly, Your Honor. I can
okay, very, very well. It looks like we're having some trouble getting Mr. Bagatko in here. Mr. Friedman, can you apprise me of what's going on?
You're on mute, Mr. Friedman.
Thank you, Mr. Lee. Yeah, he's texting me now. He said he's tried a few times and his app is acting weird. So I will be here in his stead until we can get him on. Is he not showing up on your end?
No, I keep admitting him.
Oh, that's
And it just says joining.
He just messaged me. He thinks he's in the waiting room now.
I admitted him.
Okay.
The only person in the waiting room that's not been admitted is our witness.
All right, I let him know, hopefully.
Okay, but you're ready to proceed?
Yes.
Okay, very well. Okay.
Madam Hearing Examiner, this is
Yes.
Major Buchanan. I believe she already
Hi,
emailed
Major.
you, but I just wanted to let you know that Miss Drake is having issues joining. She's having some issues with her microphone, so she's trying to get in as soon as she can, but she may be a
Okay.
little bit delayed.
Very well. She did email me, and thank you for that update. Okay, all right. Well, we're getting ready to begin our hearing. So all attorneys set to participate in this case should have their audio and video ready. Okay, good morning. Mr. Lee, if we can go back on the record. Again, I advise people we are live streaming on YouTube. We're beginning the second day of our hearing in case number 22-00286 UT. This is in the matter of SPS's request for revision in its rates and matters concerning abandonment and or extension of some of its generation plant. And before we began our hearing, we've had a brief discussion on updates concerning witness availability. All of that is appreciated. And we're gonna begin let me go ahead and admit a witness. We're gonna go ahead and begin or continue our evidentiary presentation of SPS's witnesses. And I just wanted to let parties know that upon review of the pre-hearing memos and based upon my review of SPS's testimonial filings, I am tentatively ready to waive the appearance of 3 SPS witnesses because I believe that I understand their testimony and I have no questions for them. Again, this is a tentative ruling, and should the commissioners or circumstances necessitate calling the witness, then that witness would actually have to appear. So right now, tentatively, I would be willing to entertain requests from SPS to stipulate in the testimony of Mr. Koch, Ms. Koch, Ms. Naomi Koch, the tax witness. I would be willing to stipulate in the testimony of Mr. Kopp, who was sponsoring the dismantling study. And I also would be willing to stipulate in the testimony of Mr. Davis, the director of accounting, testifying on the manner of accounting methods used in this case. So, does anyone, if I missed any planned cross-examination, did anyone have cross-examination questions for Ms. Koch, Mr. Kopp, or Mr. Davis? Hearing none, Ms. Hardy, shall we address that, or would you like to go ahead with your witness, Mr. Bell?
Your Honor, I'd be happy to stipulate in and move the admission of those exhibits, the testimony associated with those witnesses.
Very well. Why don't we do that?
Okay, the first exhibit would be the direct testimony of Brian R. Davis, which is SPS Exhibit 20.
All right.
I would move the admission of that testimony into the record.
And similar to yesterday's questions, Ms. Hardy, does Mr. Davis's direct testimony, SPS Exhibit 20, conform to the requirements that I set for stipulating testimony into the record for the parties?
It does.
And the version of the of Exhibit 20 that you're offering, is it in fact the Exhibit 20 that was placed by SPS in the Dropbox?
Yes, it was.
And I show that SPS Exhibit 20 is a document of 1,381 pages. Is that correct?
I was just going to pull it up to make sure. But I believe that would, yes, that's correct, Your Honor.
Very well. Is there any objection to what has been identified as SPS Exhibit 20, the direct testimony of of Mr. Davis? Hearing no objection, SPS Exhibit 20 is admitted. Ms. Hardy?
Thank you. The next set of exhibits are for witness Naomi Koch, and her direct testimony is Exhibit 30. Her supplemental testimony is Exhibit 31, and her rebuttal testimony is Exhibit 32. And all of those testimonies comply with the requirements that have been articulated for the submission of stipulated testimony.
And SPS Exhibit 30, the direct testimony of Ms. Koch, that was submitted into the Dropbox as a document of 115 pages. And the version that is the exhibit you're asking to be stipulated into the record, Ms. Hardy?
That's correct.
And her supplemental testimony, which has been identified as SPS Exhibit 31, that was placed into Dropbox, is a meager 9 pages. Is that the document that you're asking be admitted as SPS supplemental exhibit?
And that in John Burbank. Good.
Any objection to what's been identified as SPS Exhibit 31, Ms. Koch's supplemental testimony? Hearing no objection, SPS Exhibit 31 is admitted. And SPS Exhibit 32, Ms. Koch's rebuttal testimony is a document that was placed in Dropbox of 20 pages. And that's the version of SPS Exhibit 32 that you're offering to have stipulated in. Is that correct?
That's correct.
Any objection to what's been identified as SPS Exhibit 32? Hearing no objection, SPS Exhibit 32 is admitted.
Thank you. The final exhibit is for witness Jeff T. Kopp, and that is SPS Exhibit 80, and it is his rebuttal testimony. And that testimony also complies with the requirements regarding stipulated testimony.
SPS Exhibit 80. Is Mr. Kopp's rebuttal test? No, I'm sorry.
That's correct. It is his rebuttal.
Correct, his rebuttal testimony. And it includes an attachment JK-R2 that is an attachment of 47 pages and is entitled SPS Dismantling Study. Is that correct?
That's correct.
And the attachment to Mr. Kopp's testimony is in fact a complete version of that study. Ms. Hardy?
That's correct. It is.
Very well. Any objection to what's been identified as SPS Exhibit 80? The rebuttal testimony of Mr. Kopp, including the dismantling study. Hearing no objection, SPS Exhibit 80 is admitted.
Thank you.
Thank you. Very well. I believe that takes care of the three stipulated witnesses. And I also believe that you have another witness, Ms. Hardy.
We do, Madam Examiner. SPS's next witness is Mr. Richard Belt, and Mr. Moss is going to be presenting his testimony.
Okay, good morning, Mr. Moss. Good morning, Mr. Belt.
Good morning.
Good morning, Your Honor. It's good to see you again. My name is Ron Moss from Winstead Law Firm in Austin. This time we present Richard Belt.
Mr. Lee, would you please swear in the witness?
And Mr. Bell, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, nothing but the truth. So help you God?
Yes, I do.
Thank you, sir.
Thank you, Mr. Lee. Go ahead, Mr. Moss.
Thank you, Your Honor. Mr. Belt, please state your name for the record, please.
My name is Richard L. Belt.
By whom are you employed, Mr. Belt?
When I filed testimony in this case, I was employed by Xcel Energy Services as the Director of Chemistry and Water Resources. Just recently, I have become a consultant to Xcel through a third-party company.
Okay. Do you have in front of you what has been marked as SPS Exhibit 50?
I do.
And can you identify that, please?
Exhibit 50 is the direct testimony of Richard L. Belt on behalf of Southwestern Public Service Company.
And does your testimony contain 3 attachments?
It does.
Okay. Was that testimony, or was the testimony and attachments prepared by you or under your direct supervision?
Yes.
Okay. And if you were asked the same questions today, would your answers be the same?
Yes, they would.
Okay. Your Honor, this time we move for admission of SPS Exhibit number 50.
Mr. Belt, are your answers true and correct to the best of your knowledge?
Yes, they are.
Any objection to what's been identified as SPS Exhibit 50? Mr. Belt's direct testimony. Hearing no objection, SPS 50 is admitted.
Thank you, Your Honor. Mr. Belt, do you have in front of you what has been marked as SPS Exhibit 51?
Yes, I do.
Can you identify that for the record, please?
Yes, it is the rebuttal testimony of Richard L. Belt on behalf of Southwestern Public Service Company dated May 10th, 2023.
And does that testimony have any attachments to it?
No, it does not, I believe.
Okay. Was that testimony prepared by you or under your direct supervision?
Yes, it was.
If you were asked the same questions today, would your answers be the same?
They would.
And are those answers true and correct?
Yes, they are.
Okay. Your Honor, at this time, we would move for admission of SPS Exhibit number 51.
Objection to what's been identified as SPS Exhibit 51, Mr. Belt's rebuttal testimony. Hearing no objection, SPS Exhibit 51 is admitted.
Your Honor, at this time, we tender Mr. Belt for cross-examination and the hearing examiner's questions.
Thank you so much. I believe Ms. Lynch, that you requested 40 minutes for this witness.
Correct.
All right, please proceed.
Okay. Hello, Mr. Belt. My name's Kara Lynch. I'm the attorney for the Coalition for Clean and Affordable Energy.
Morning.
It's nice to meet you. And virtually. I think this is the first time I've actually seen your face. So let's see here. These questions are going to focus on the water modeling that you did for the Tolk well field. First of all, I wanted to start with a very basic question around the definition of economically recoverable water. How does SPS define economically recoverable water?
Economically recoverable water, for purposes of SPS's definition, is that water which resides in the aquifer at or above a saturated thickness of 40 feet.
And how many acre feet of water in your estimation is that?
I would have to review my notes in the last study, but it's in the neighborhood of 100,000 acre feet or so.
Okay, is economically recoverable water a term that's commonly used in your profession?
Yes, it is.
Okay, so it isn't specific to SPS.
No.
Okay. What characterizes the economically recoverable groundwater in the Tolk well field then?
Can you be more specific?
Well, what were you using to define or examine, the characteristics of the economically recoverable groundwater in the Tolk well field?
Okay, so I guess referring back to my definition, that would be the groundwater that's owned by SPS within the well field that is in the saturated thickness of the aquifer above a depth of 40 feet. So depths greater than 40 feet of saturated thickness.
Okay. Can you describe for us what you mean on page 25 of your direct testimony, which is Exhibit 50, when you discuss the depletion window?
Yes. So the ability to produce water from a well depends on a number, or a well field rather, depends on a number of factors. Physical factors related to the aquifer itself, the size and location of the wells within that well field, and things of that nature. And so there's a range of time or a range of volume at which, or a range of saturated thickness, these are all sort of equivalent terms, at which producing water from that well field has some degree of uncertainty as you approach that 40 feet of saturated thickness. That is what's described as the water depletion window, when that uncertainty starts to mount.
And what are contributing factors to that uncertainty?
Probably the largest contributing factor to the uncertainty in the Tolk well field is the size of the well field itself. And so the well field has a total surface area of approximately 50,000 acres, over which are arrayed a series. I think we're at about 94 wells arrayed over that well field. And so the depletion window itself ranges from 20,000 acre feet to 50,000 acre feet. So that is approximately 1 acre foot per acre at the 50,000 acre foot level, down to, a little less than half of an acre foot per acre of recoverable water at the 20,000 acre foot lower end of the window.
You just used the term recoverable water. Can you define for us what you meant by recoverable water?
Yes, it relates to the economically producible water definition that we were speaking to earlier. That water, which could be produced by SPS's well field for the purposes of use at Tolk Station.
Thank you. I'm trying to block out some of the background noise related to someone else's alarm right now. So that's why I'm going on mute when you're answering. When do you expect the economically recoverable water will be depleted in that well field?
That is related to the demand and the use of the water. So for the purposes of this answer, I'm going to say 2028 under SPS's preferred operation scenario for Tolk Station at 4,000 gigawatt hours per year.
Could you turn to page 11 of your testimony?
The direct testimony, Ms. Lynn?
Yes, we're only in the direct testimony right now, but thanks for clarifying.
Yes, I'm there.
And at the top of that page 11, there's a graph. Would you mind walking us through what this graph means?
Sure. This is a graph depicting the historic saturated thickness in the Tolk well field from approximately 1949 through 2022. Or sorry, through 2021. The red dotted line toward the bottom of the chart, it depicts 40 feet. And so that's tied to this economic depletion thickness of 40 feet. And so the blue dots and then the line itself. So the dots are either measured saturated thickness within the Tolk well field corresponding with the year, And then the line is sort of a best fit trend through those series of dots.
This graph only goes through 2021. We could conceivably construe it for the date of 2028, where the blue line would meet or surpass the red line. Is that correct?
So if you zoom in, if you can, I'm not sure the capability of the zooming here, toward the later years on the graph. You'll see that there is a slight inflection point almost right where the hearing examiner had the cursor just a moment ago, where the slope of that line begins to flatten. The slope of that line is beginning to flatten because the usage of water within the Ogallala Aquifer by other parties, most notably agriculture surrounding the Tolk well field, has begun to decline because their own wells and possibly well fields in some cases are beginning to be unable to produce water to serve their overlying agricultural purpose. And so if we have a few more dots out there arrayed to the right as you're looking at the chart, I expect that those dots will follow that similar flatter slope out to 2028 and beyond, frankly.
Well, it continues to, I mean, that's a very close margin between the blue dot or square and the red line. What
Is that a
what do
question?
you, it's leading into this next question. Based upon that information, what do you expect SPS might do if the plant needs to operate for a year or more after 2028? If, as you stated, under the scenario that was used in the modeling, SPS has used all of the economically recoverable water by 2028.
I think there are a number of options, and SPS is employing a number of approaches here to try to keep track of that depletion as we approach that economic recoverability threshold. So most notably, SPS updates its groundwater modeling annually. And with that modeling update, it takes into account water levels throughout the modeling domain, which is simply a fancy word to say that the limits of the spatial limits of the model. And so as those water level data are collected, those are used by our consultant to calibrate that model and then forecast forward based on our demand and the demands of the other non-SPS water users within the domain out into the future. And so the primary benefit of this approach is that every year we get a forward-looking projection, and that projection gets better and better because the years of the forecast are reduced as we approach the ultimate retirement of the plant.
Thank you. So for various reasons, you described that the water being pumped out in this well field might begin to flatline, mostly because of declining agricultural use. And the reasons for that declining agricultural use vary. One of the reasons is the constraint put on that sector of its water use. Are you aware of any constraints that exist for the utility sector on its use of water in the Ogallala?
Your Honor, I'm going to object. She's assuming facts not in evidence by stating that there are limits on other users' production of water.
That was presented in SPS testimony.
Where?
It relates to the High Plains agreement. I'd have to refer, there it is. You see that? Go down, scroll down to the page 10. The High Plains Water District has, put some restrictions on the agricultural users, and that was pulled from SPS testimony. Right now, I don't have the exact site. I apologize, but I can get that for you.
Mr. Moss?
Well, I would like to have the site before she starts asking him questions based on the assumption that other users are limited in the amount of water that they can take from the aquifer, because I don't think that's been established.
Ms. Lynch, we need a specific site if you're going to address a particular part of testimony that you believe that the witness has put forth.
We'll come
Otherwise-
back to that if I
Okay.
can find that citation in the time that we have.
Okay, very well. You're at 25 minutes.
Great. Do you agree that SPS analyzed two scenarios here? One for the early retirement of 2028 and one for the current schedule of retirement in 2032?
Yes, I do.
Was economically recoverable water at Tolk used as a constraining factor in those scenarios?
It was used in those scenarios. Whether it was a constraining or driving factor, you might have to refer that to Mr. Elsey.
Okay. I'll take note of that. Thank you. Onwards. What is the, that's, so in your opinion, could SPS have run an analysis to show a scenario that does not deplete all of the economically water that's available to SPS by 2028 or 2032?
I'm going to defer that one, or ask that you defer that to Mr. Elsey too. The financial scenarios are not my area of expertise, just simply the impact on water.
Okay. I mean, do you believe that a least cost scenario where SPS conserves some of the economically available water could have been run?
I suppose any number of scenarios could have been run, but as to the utility of it, I think Mr. Elsey is best qualified to answer that.
That might have presented a fuller picture to the commission of various options available.
Again, not my area of expertise, I'm sorry.
Well,
okay.
Let me ask you this, Mr. Belt, if the analysis of the water, and how much there is and how long it might last is your area of expertise, correct?
Yes.
Well, if you're told to run a certain scenario based on economic factors, and it shows that the water may play out at a certain year under certain usage patterns and everything else, I mean, as the person who's the most knowledgeable about the water and how long it might last, weren't you curious of trying to project how much longer the water could be utilized?
Sure. And actually Tolk's operation is probably the primary driver on the rate of depletion of water in Tolk's well field. And so if you use more, there's more water withdrawn from the aquifer. If you use less, there's less water withdrawn from the aquifer. That's not the whole picture, but that's a significant driver of the picture. The other driver is use by parties primarily for agricultural use who are within our model domain, but outside the Tolk well field. And so if Tolk were to use less water, then over a period of time, that water would flow from the relatively thicker saturated thickness underlying the Tolk well field out to the surrounding water users where they've drawn the aquifer down further over time. And then SPS, would lose the ability to produce that water because it would not exist anymore under its well field.
So basically then, if I'm thinking about this, and again, I don't know that people really liked my driving to Albuquerque yesterday, but I try to visualize, in my head, and what I'm visualizing after just hearing what you answered is that if there's a big bowl of soda in the middle of the room and you have different people with straws in that bowl of soda, what I thought I heard you say is if SPS takes its straw out of the bowl of soda, then that means there's more for everybody else. And that they're going to drink your part of the soda.
They can try to drink our part of the soda. They are similarly constrained by an economic recoverability constraint, the same as we are. It's driven by the size of their wells. Most agricultural operations are using high capacity wells, again, so they have less infrastructure and it controls their costs and things like that. So their threshold of economic recoverability is going to be similar to that we see in Tolk. So
what is a high capacity well?
Oh, in my mind, a well that's above 200 gallons per minute or so is a high capacity well.
And they're able to get that kind of gallon per minute flow because of the equipment that they use?
Yeah, the equipment that they use is sort of the basic threshold that they have to overcome. Then the aquifer that well is installed in has to be able to flow water through the geology to that well to be produced at that rate. And what you find as the aquifer is drawn down is that there's a decreasing amount of well screen and a decreasing amount of hydraulic head. So the screen is what allows water to flow into the well to be produced by the pump at 200 gallons per minute. And then the hydraulic head is the slope of water in the surrounding aquifer that is pushing water, if you will, toward that well to then flow through the screen and then be produced by the pump. And so all of those things have to work in concert for the well to be able to produce that flow rate.
But you're saying basically your competition for the water out of that, or soda out of that same bowl has similarly situated wells as SPS does?
They're
The same size straw?
Yeah, they're probably similarly situated. I don't have knowledge of every single well out there, but generally they're probably similarly situated. So every part of the aquifer isn't created equal, though. It's not a bathtub as you describe in your analogy. And so the Ogallala aquifer was created over millions of years by a series of rivers that crossed through this area and laid down the the sands and gravels that built up over time and then were filled with water. And that's what the Ogallala aquifer is. So if you imagine the current landscape today with hills and valleys and you know, high and low spots, places where there might be more gravel, which is more transmissible for water, versus maybe some silts, which are less transmissible. You know, you don't have perfect knowledge of that from the surface when you're drilling a well. And so, you know, you as a water user may have lucked out and come up with an old riverbed with gravels that's at the low part that your well performs very well. You may have gotten unlucky where you put your well onto kind of a high spot, and that well is now unable to produce water at the same rate, even though a lot of the characteristics are similar to your neighbors, say.
Thank you. I appreciate that explanation. Ms. Lynch, I stopped your time when I began asking for clarification. So I'm going to start your time again. It's 22 minutes.
Thank you. So regarding the current use of water at Tolk, is that use at a lower level than the scenario that was run for 2028?
I'm sorry, the current use today?
Yes.
You might have to ask witness David Lau about the current use of the plant. Over the last several years, the plant's usage has been at various different levels, and it's my understanding that it's not being necessarily constrained by any adders or anything right at the moment.
Are you aware of water being one conservation factor for the optimization plan that's currently in place for Tolk?
Yes, water was one factor in that optimization plan,
Which was capped at 2,400 gigawatt hours per year, correct?
I believe that is correct.
Okay, so under the current plan that you analyze, or no, under the scenarios that you analyzed, would you agree that in those presented scenarios, SPS plans to use all of the economic water available to it?
Under the 4,000 gigawatt hour per year scenario that was presented, the economically producible water will be generally consumed from under the Tolk well field in that scenario by 2028.
Okay.
In
your expert opinion, then, if the plant is unexpectedly needed longer after the economic water has been used, what are the options available to SPS, and are they more expensive?
As I explained earlier, I think SPS has quite a few options. One, we will continue to update the groundwater model every year between now and the retirement of the plant so that we have an up-to-date and accurate view of our water bank, if you will, heading toward retirement. So should something change in our projection that causes toll to need to be extended by a year, let's say, into the future, SPS can alter Tolk's operation to leave that necessary water available to allow the plant to run, should that become apparent between now and the ultimate retirement date.
So water would be a factor in determining the level at which Tolk could be used.
Yes, I think it would be one of the factors that would be considered.
Okay. In your opinion, would risk to ratepayers increase if SPS runs out of its economical water?
This might be a question better addressed to Mr. Elsey, but my understanding is that the preferred option resulted in the best outcome, financial outcome for SPS customers.
Which is to use all of the economical water.
Which is
Correct.
to generate Tolks at the 4,000 gigawatt hours per year. And then the consequence of that is that the economic water is used. So I would flip the priorities.
Okay. So under the scenario run, would it be imprudent for SPS to not use all of the economical water available to it?
I'm not an expert on imprudency and those types of policy decisions. I would simply say that SPS's customers have paid for that water asset and the infrastructure necessary to produce that water and deliver it to the plant, and that the 4,000 gigawatt hour per year option allows SPS customers to realize the benefit of that investment.
Okay, those are my questions for you, Mr. Belt. I thank you, Hearing Examiner Hurst.
Thank you, Ms. Lynch. I do not believe that anyone else had scheduled time for Mr. Belt. I do have a few questions for you, sir. Welcome. And I know that Ms. Lynch asked you this, but I'm going to just follow up to make sure that I understand. And I'm referring to page 4 of SPS Exhibit 50, which is your direct testimony. I've got it on the screen here. And in your footnote, you're giving the definition of economically recoverable water. And I think you've already answered, you've told me what a high capacity well is. And so am I to understand that that this economically recoverable water under the definition has to be at least 40 feet above the saturated thickness, or based on what you're telling me about my soda bowl not being configured that way, that it has slopes and it has highs and it has lows. Can that 40 feet vary depending on the characteristics of the aquifer?
Yes.
Or is that just a standard measurement of it's the 40 feet? You know, it's the top of the black and tan.
Yeah, it's an excellent question, and there are a number of variables that factor into the 40-foot threshold. First is the size of the wells that you're using to produce the water. So a 200-gallon per minute well exerts a certain pull on the aquifer. It can move a lot of water. And so as the relative depth gets lower, the slope that you can achieve with the water remaining in the aquifer to push water or flow water toward that well, there gets to be a maximum on that, because you can only start your slope at the bottom of the well, right? So if you had 100 feet deep, you could get a very steep slope. At 40 feet, there's a limit on what that slope can be. And so the rate of movement is constrained relative to the 200-gallon per minute well that you're trying to serve. Now, if you installed a 10-gallon per minute well, that 40 foot might be able to create that steeper slope that would serve that well and allow that drawdown to be even more, because the amount of water that you're trying to move is so much less. So that's one variable. Other variable is the physical characteristic of the aquifer itself. So if your aquifer at the location that you have installed your well happens to be made of larger grain materials like gravel, if you can imagine, the pore spaces between the gravel elements are larger, and the amount of water that could be moved through that pore space would be relatively higher versus small particles of sand where the spaces are much smaller, and that imposes a limitation. Just the aquifer itself imposes a limitation on the amount of water that can be yielded. And what that looks like to the well is that it's trying to create this big slope that's moving water rapidly, but the pore spaces are presenting a physical constraint. And so while it's trying to produce this, you actually get something much flatter than that, and that the well does not perform at the volume expected.
And what I'm kind of wondering, and I guess I'm trying to put this in the context of my own understanding as it relates to a residential well. And I've got a well that is basically, that's why it's very interesting to me to have a 200-gallon per minute. I have one that barely qualifies for to meet the gallon per minute for residential purposes. And whoever put this system in actually, and because of the distance that it has to get pumped from where the well is to the house, put in a holding tank to pump that into, and then a booster to actually pump it to the house. So in terms of that kind of configuration, are there technologies that are much more advanced than that, but similar to that can assist in utilizing water in less than optimal circumstances?
Yeah, there are, and frankly, they're not a whole lot different from the setup that you describe at your home. They're just bigger. And so Tolk has many of these features already in place. So between the well field and the plant itself, and located more or less on the plant site, is a very large holding lagoon. The volume required is too large to hold in a tank, so it's a large reservoir, and that allows the well field to pump at a rate, but that rate doesn't have to be coupled with the demand that the plant is exerting. So there's a little bit of a buffer there that allows the well field and the plant to operate independently of each other, which allows the plant to operate as it needs to in the market. The gathering system so there's 94 wells, I believe I mentioned. There's a long series of pipelines that convey water from those wells, first to plant X and then to Tolk. Those pipelines, require some help at times, especially from plant X to Tolk, to keep that water moving along and then ultimately arrive at Tolk. So it's not dissimilar. Some additional things that Tolk has implemented to try to get the best bang for the water buck being produced is, so plant X produces wastewater. Plant X is also served by this well field. So it produces wastewater following its use of water. That water is piped to Tolk and blended with the water produced in the well field to further extend Tolk's water supply. And then probably the primary way that Tolk makes the best use of the water that it produces is that it cycles water through its cooling towers a number of times. This gets a little complicated, but basically all water carries some chemical constituency, that is imparted to it by the geology that it's residing in. So it has dissolved minerals and things of that nature. The plant employs various advanced chemical treatment processes to manage the buildup of those minerals, because if they evaporate out on the equipment, they scale and can damage the equipment or reduce the efficiency of the operation. So through chemistry, they manage this scale buildup within the cooling towers, and that allows the plant to continue to cycle this water and concentrate those minerals more and more. So Tolk operates at a cycles of concentration of 20 to 25 times, which is among the best achievable cycles in the entire industry. And so that has two benefits. One, we get the best bang for the buck water-wise, but two, Tolk is a zero discharge plant, so there's no river or stream that wastewater can be discharged to, and plus the water quality when we're done with it is terrible. So it's then evaporated on site in a series of ponds. By using water so efficiently, it allows us to decrease the cost and effort associated with those ponds. Also, we need fewer ponds, and they require less cost to build and maintain.
Do you get a lot of naturally occurring arsenic?
I am not aware of arsenic specifically in the groundwater at Tolk. I will tell you that there are some low density, agricultural, residential, folks who live in that area who produce their own water via wells. And I'm not aware of any special treatment needed to make that water potable both for those folks and at the plant itself for potable use for the employees there.
And your lagoon, is it a man-made lagoon, or is it a natural feature?
No, it's constructed, it's lined to minimize any loss of water out of it.
Okay, so there's not like any fish in there. Or,
Nope.
okay.
No surface water features around the plant
Okay.
from which a fish would come.
No canoeing or boating on the lagoon.
No, ma'am.
Okay. And with regard to your footnote and your description on the high capacity, and you've indicated 93 or 94 wells SPS has in the Tolk well field?
Yes.
Okay, so those are SPS wells in the Tolk well field.
Yes.
How many other, or are there any other wells in the Tolk well field?
That is a good question. There are stock water wells. So Tolk produces water from underground, and then the plants have a relatively small footprint within the well field. The surface of the well field is covered generally with grass, and it is grazed by local agricultural producers. And those producers have installed really low capacity, like less than 15 gallon per minute stock water wells and stock tanks so that their cattle can drink and so forth. There are several of those scattered throughout the Tolk well field. There may also be some homes throughout the Tolk well field that would have small, probably 10 gallons per minute or less domestic wells. Other than that, I was going to say, other than that, no. Now, all around the Tolk well field, there are lots of water users.
And you said the size of the Tolk well field is?
Approximately 50,000 acres.
50,000 acres. And did I hear you say that the equivalent acre feet size would be 100,000 acre feet in that 50,000 acres?
Yeah, based on our most recent modeling and my recollection, I believe there's approximately 100,000 acres of recoverable water residing in the ground or in the well field. So there's also water below 40 feet, and I'm not talking about that at all. Yep.
Right. No, okay, if we can look at page 7. Okay, so you're posed the question on page, just for clarification purposes of the record, I like it. I like that you smiled and you understood what I meant by a black and tan. Just to clarify for the record, black and tan is a glass of beer with two different beers, one being lighter and one being darker, and eventually they can commingle. Sometimes they stay separate depending on who pours and which beers. I won't say which beers because I think there's traditional and non-traditional. So that's the clarification on that. So let's look at page 6, and the question posed at 9's line through 11 is, what's the primary driver for SPS's plan to generate electricity from Tolk at approximately 4,000 gigawatt hours per year between 2023 and 2028, and then to cease coal operations at Tolk in 2028? You begin your answer at line 12 on page 6, and I'm focused in on beginning on 14, an expected dispatch scenario of 4,000 gigawatt hours per year between 2023 and 2028 will enable SPS customers to continue to, number 1, receive low-cost energy from Tolk's coal operations, particularly in periods of higher gas prices. Number two, while prudently managing the declining water availability in the Tolk wellfield. And then on to the next page, page 7, preserving the value of Tolk's accredited capacity on SPS's system through the time frame until replacement generation resources can be determined following SPS's next integrated resource plan process. That's your testimony, sir.
Yes.
I have a question about 3. Preserving the value of Tolk's accredited capacity on SPS's system. What specifically did you mean by that?
The specifics of accredited capacity, you may need to direct to Mr. Elsey, but my understanding is that Tolk needs to be available to generate at its full load for a certain period of time within the Southwest Power Pool system in order to be accredited as having 1,082 megawatts of capacity to meet the company's requirements based on the load that they're trying to serve. And so the plan here would be able to maintain Tolk's accredited capacity and meet those criteria up through the retirement in 2028.
But basically you're referring to we have this asset and it has a monetary value. And we want to maintain that monetary value. Correct?
Mostly with regard to item 3, I'm referring to the fact that Tolk can produce a certain amount of energy, and we have to be able to produce a certain amount of energy in order to serve our load under the SPS system. And SPP requires us to maintain that accredited capacity, and having water is fundamental to Tolk being able to operate and be able to fulfill that capacity function. I'm operating right at the edge of what I understand right now in terms of how that capacity is calculated and things like that. Those are questions best directed probably to Mr. Elsey.
I understand, but that it's your testimony.
Yep.
But it sounds like what I'm hearing is it's not just a monetary value, but it's also a potential compliance with SPP commitments. Is that correct?
With regard to item 3 there, it is primarily the compliance piece that I'm referencing.
Okay. I thought I had a question about saturated thickness, but so your testimony on page 8 regarding beginning with the question that posed at line 5, does historical data show the economically recoverable groundwater in the Tolk wellfield has declined over time? You begin your answer at line 7. And I guess I'm concerned mostly with the end of line 9, there was approximately 170 feet of economically recoverable saturated thickness in the Tolk well field. Apparently in the late 40s. That's correct.
Yes.
So, but now it's only 40 feet.
Probably 48 or so feet in the Tolk well field on average.
So roughly then it's declined 120.
Yeah, approximately, yes.
Okay.
To understand that, I think there's that chart that we reviewed earlier that shows that decline.
Right.
I'm sorry, I don't remember what page it's on. It's on
there it is.
page 11.
Uh-huh.
And so in the 1940s, just after World War II, vertical turbine pumps became affordable and were used by affordable for agriculture. And so thus they were deployed to use the fertile panhandle ground, for economic production of agriculture. So 1940, where you have your cursor, that's where we started. And then in the early 1980s, there's that dot that lies to the lower than the blue line. So just immediately to the right of that is when Tolk came online. And so the vast majority of all water produced in the Texas Panhandle or from the Ogallala, over its entire 8-state area is for agricultural purposes. And you can see there was a large decline of groundwater before Tolk even came into existence.
And you indicated that on that 50,000 acres from the well field, does SPS own that 50,000 acres?
It owns parts of it. Mostly the surface is owned by an individual landowner, mostly engaged in grazing. And Tolk owns the groundwater rights, which have been severed from that surface estate.
And so if it's like a big ranch, cattle are grazing over your water?
Generally speaking, yes. It's a sandhill area that is primarily comprised of wind-blown sand that have arrayed themselves in a series of hills, and it was never arable because the ground couldn't be flattened, and the sandy nature of the overlying soil made it very difficult to irrigate. So people didn't even try, really.
Hmm. Sir, on page 23 of your testimony, you're talking about the question posed on beginning or on line 3. What conclusions do you draw from the 2021 groundwater study results? Then you begin your answer on line 4, and then at line 6 you say a new groundwater study is currently underway, which will, and you go on to the next page, page 24, which will update the aquifer conditions and operating scenario based on 2022 data. This model should be available in January of 2023. Did that study conclude, sir?
It did. And we produced it in discovery in this proceeding.
And did you update your testimony with this new model?
I did not. I responded to some discovery questions around it.
Did the new model change any of your conclusions or change your, is the graph related to the study?
The graph that you're looking at there is from the 2021 study. The 2022 study contains a very similar graph. The changes between 2021 and 2022 are primarily as follows: the calibration of the model based on new data that was obtained about groundwater levels, saturated thicknesses throughout the model domain, changed from 2021 to 2022. And also there was some fine tuning of the demand scenarios imposed by proposed TOLC operations, which changed between 2021 and 2022.
Okay.
The charts are very similar. The conclusions are very similar.
Okay. I think, sir, that's all the questions that I had for you. Mr. Moss, any redirect for your witnesses?
Yeah, just a few questions, Your Honor.
Go ahead.
Mr. Bell, I think you may have said this, but just to make clear, did the 2022 study that you were just discussing confirm your conclusions in your testimony, or did they change them at all?
They did not change them at all.
Okay. You, in response to Ms. Lynch's questions, you said that if the groundwater is depleted before 2028, there are a number of options that the company has. Do you recall that?
Yes, I do.
Okay. And one of those options was that you said that you are continuing to do new studies each year and you could modify operations. Do you recall that?
Yes.
What does that mean when you say you could modify operations?
We could alter the level of generation at TOLC station. So we could likely, if we were running out of water, which I believe was the premise of Ms. Lynch's question, then we could reduce generation at TOLC station if that was, if required to match the new situation that we determined.
Okay. And in terms of, you also discussed a lagoon that exists at the TOLC station. Do you recall that?
I do.
Does that lagoon present any other options for the company on a short-term basis?
Sure. On a very short-term basis, the lagoon holds, I believe, approximately 115 million gallons of water. And so that is a substantial amount of water and would allow the plant to augment flows that were produced from the well field to allow the plant to operate up to its full load for a period of time.
And will that lagoon continue to be replenished after 2028?
I expect that lagoon will continue to be replenished after 2028. The synchronous condenser that have been installed at the plant, I believe, are slated to retire in the 2050s. They will require a much smaller amount of water, but some water in order to operate, primarily for cooling of them, and also for personnel at the plant. So there will be an ongoing need at TOLC station.
Okay. And a number of times you referred questions to Mr. Elsey. Can you just so the record's clear, can you define the allocation responsibility between you and Mr. Elsey for these studies that we're talking about?
Sure. I'm sorry, can you clarify which studies we're speaking of?
These optimization scenarios that we're talking about, the 4,000, so forth.
Gotcha. Yeah, thank you. Mr. Elsey is primarily responsible for preparing those financial models around the optimization of the operation of TOLC station. The groundwater can pose a constraint on that. So Mr. Elsey and I work fairly close together to understand if water is becoming a constraint on the scenarios that he is proposing.
Okay, thank you. Those are all the questions I have, Your Honor.
Thank you, Mr. Moss. Anyone have questions for Mr. Belt based on either the redirect or my questions? Ms. Lynch?
I see that Miss Beatles of WRA has questions, and then I do have a couple of questions following up on yours.
I don't see
and-
Ms.
and
Beatles
provi-
on the screen at all. So I don't know what to tell you.
Oh, there she is. I don't know who you want to go first.
My
or-
hand is, if my hand is raised, it's inadvertent. I don't have any questions.
Okay, Ms. Beatles.
Okay.
Ms. Lynch?
Sorry, great. I wanted to circle back because I found that citation that you were curious about. It is on page 6 of Belt's rebuttal testimony in response to some information that was presented by Mrs. Glick. Specifically, I'm looking at lines 3 through 11. Are you, Mr. Belt, are you aware of the High Plains Water District groundwater production limit that's imposed upon agricultural users?
Yes, I am, but I would clarify that it's not imposed only on agricultural water users. It's imposed on all water users who operate within the High Plains District.
That would include SPS.
It would.
Okay. And here at line 7 through 9, you state, and let me know if I'm incorrect. The
Tell me the
agricultural
page again, please.
Page 6. And I'm looking at line 7 through 9 right now.
Thank you.
But the agricultural producers are now limited by what the aquifer and their wells can physically produce due to the overall depletion of the aquifer underlying their lands. Is that an accurate statement?
Yeah, it's an accurate statement. Yes.
Okay. Well, that was those are my questions referring back to the source of the groundwater production limit that's imposed by the High Plains Water District. I have one further follow-up question regarding the use of water at Tolk. Currently, under the current operating plan, does SPS have any compliance issues with SPP, offering Tolk into SPP? Can you answer that?
I am not aware of any, but that's a question better directed to either probably to David Lau.
Okay. And that's the extent of my questions. Thank you.
Thank you.
Thank you. Thank you, Mr. Belt. I don't believe there's any more questions for you. So, sir, you are excused.
Thank you.
I believe now might be the appropriate time to for us to take a 10-minute morning recess, and we will come back. I see there's an SPS witness waiting for us. Ms. Hardy, who do we have ready to appear?
Madam Examiner, our next witness is Jared Cooley.
Okay, very well. We'll take a 10-minute recess and come back at 10:40. Remember, the live streaming can All right. Okay, I think we're back from our recess. And Ms. Hardy, I believe SPS has another witness.
We do, Madam Examiner. SPS's next witness is Jared Cooley, and Mr. Moss will present his testimony. And before we do that, I wanted to inquire whether it would be okay with you if I am off camera and Mr. Stewart sits in my place because he will present our witness following Mr. Cooley. I would just like to switch places with him if that's okay with you.
Very well. And I am assuming we will have Mr. Mahler after Mr. Cooley.
Mr. Mueller or Mr. DeAscendis, if the commission is ready to question him.
Okay. I can report to you that I've just returned from walking down the hallway, and the commission meeting was still going on when I walked down that way. So I think we'll just go ahead. I've just got a few questions for Mr. Cooley, and I do not believe that anyone reserved any time for cross-examination. So,
Madam Hearing Examiner, this is Joshua Smith on behalf of Sierra Club. I'm sorry to interrupt you.
Go ahead.
I would like to also request permission to step away for a little while and watch remotely.
Okay.
If I may, however, I'm not sure if we've landed in a spot where I can give Ms. Glick an idea of when she might be up. I certainly don't want to waive her ability to be on the stand if it's going to be in the next couple of hours, or if it's going to be tomorrow or Friday. Do you just wondering?
Well, now that, well, I mean, and we can talk about this. My concern was trying to make sure of having the witnesses that could only be this week, that we get all of them in. And so I think as we previously discussed, the witnesses that that I identified as having constraints on appearances were primarily the Attorney Generals, Ms. Crane, Dr. Woolridge, and Ms. Glick, your witness, Ms. Glick. Now I know other people had specific time frames, but those were the three I was trying to make sure that we got in this week, the non SPS witnesses. And according to the information I have, we have to put Dr. Warwich on Friday because that's the only day he's available. Okay, I don't think it's going to take all day. So, I mean, and Ms. Crane is available today and tomorrow. So, and then Ms. Glick, we have to hear her today, tomorrow, or Friday. So, I mean, I'm open for suggestions on, if parties, want to talk amongst themselves at lunch or whatever. I'm assuming that we're going to hear from SPS witness the Sps'S after our lunch break. And I really hadn't thought about calling the three, Ms. Glick, Ms. Crane, probably tomorrow, and then again, Dr. Warwich on Friday. Is just the rough idea. Like I say, I'm open for some, for some suggestion. If people want to, suggest a plan for me, I don't have issues. I just want you all to keep reminding me if there's a witness I haven't picked up on that we can only hear this week. Please don't wait until Friday afternoon to tell me.
And
might be a bit problematic. Mr. Getko?
yeah, the one thought I had is that, Mr. Woolridge, Dr. Woolridge may be available next week. I think when we were dealing with some of these pre-hearing memorandums and stuff and seeing kind of what the extent might be, I think I probably focused on the first week with, thinking that perhaps not knowing how long the hearing would go. I'm going to look into that. Are you getting a feel that should we look at Monday would that open up possibilities? And I'm thinking of Mr. Woolridge too, and the ability for him to enjoy his daughter's wedding.
Yeah. Don't know what to tell you about that. Obviously I have questions for some of the witnesses. And I remain flexible depending on what information is communicated to me by the commissioners as to their availability and the witnesses they want to question. Okay.
All right. Well, I'll just get my ducks in a row and be ready for that same flexibility. Thank you very much.
Okay. Thank you. I know didn't provide a whole lot, Mr. Smith, to Ms. Glick, but again, it will probably not be today. It will probably be tomorrow for Ms. Glick.
Okay, thank you.
Okay.
Appreciate it.
Okay, very well. Okay, if we don't have any other procedural issues to discuss.
I I do have the same inquiry about the CCAE witness Noah Long. We did not necessarily expect this to go into next week. He could go next week. And then he's on the East Coast right now. So, I think he needs to conclude by 4 p.m. Mountain Time. That was the constraint that was brought forward this week as a result of the pace of the hearing. Is there any indication that you can give as to when Mr. Long might be called?
No. Not at this time, Miss Lynch. But I have noted that it would be better if he is a morning witness.
Much appreciation.
Okay.
Yep.
All right. Well, let's go ahead then. And I believe, yes, there's Mr. Cooley. Hello there, sir. And Mr. Moss, I believe you're presenting Mr. Cooley.
Thank you, Your Honor.
Go ahead, sir.
Thank you. We need to swear in the witness first.
Okay. Well, I thought that's very well. Mr. Lee, would you please swear the witness, sir?
Mr. Cooley, would you please raise your right hand? You do solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir.
Thank you, Mr. Lee. Go ahead, Mr. Moss.
Thank you, Your Honor. Mr. Cooley, would you state your name for the record, please?
Good morning. My name is Jared J. Cooley.
By whom are you employed and what position?
I'm employed by Southwestern Public Service as Director Strategic Planning.
Okay. Do you have in front of you what has been marked as SPS Exhibit 21?
Yes, sir.
Can you identify that document for the record, please?
The direct testimony of Jared J. Cooley on behalf of Southwestern Public Service Company.
Okay. And do you have attachments to that testimony as well?
Yes, sir.
And are these the same attachments that were in the file testimony?
Yes, sir.
Okay. Have you excluded any attachments from this testimony?
Not in my direct testimony.
Okay. Was this testimony, were testimony and attachments prepared by you or under your direct supervision?
Yes, sir.
All right. If you were asked the same questions today, would your answers be the same?
Not withholding what was updated in the supplemental testimony. Yes.
Okay. And are those answers true and correct to the best of your knowledge?
Yes, sir.
Your Honor, at this time we move for admission of SPS Exhibit 21.
Any objection to what's been identified as Mr. Cooley's direct testimony on behalf of SPS as identified by him here today? My understanding is that SPS Exhibit 21 also contains attachments verified by Mr. Cooley, and SPS Exhibit 21 is a 31-page document that was submitted by SPS into the Dropbox. Correct, Mr. Moss?
Yes, Your Honor.
Are there any objections to SPS Exhibit 21? Hearing none, SPS Exhibit 21 is admitted.
Thank you, Your
Mr.
Honor.
Moss?
Mr. Cooley, do you have in front of you what has been marked as SPS Exhibit 22?
Yes, sir.
Can you identify that document for the record, please?
The supplemental testimony of Jared J. Cooley on behalf of Southwestern Public Service Company.
And was this testimony prepared by you or under your direct supervision?
Yes, sir.
If you were asked the same questions today, would your answers be the same?
Yes, sir.
And are those answers true and correct?
Yes, sir.
Your Honor, at this time we offer SPS Exhibit 22 into evidence.
SPS Exhibit 22, Mr. Cooley's supplemental testimony as verified by him here today. A document of 9 pages that was placed by SPS into the Dropbox. Mr. Cooley, the attachment to SPS Exhibit 22, the attachment JJC-1 sub contains highlighted versions. The highlighted versions differ from the rest of that attachment because they were updated on March 27th. Is that correct?
That is correct.
Thank you, sir. Any objections to what's been identified as SPS Exhibit 22? Hearing none, SPS Exhibit 22 is admitted. Mr. Moss?
Thank you, Your Honor. Mr. Cooley, could you identify what has been marked as SPS Exhibit 23?
Yes, SPS Exhibit 23 is the rebuttal testimony of Jared J. Cooley on behalf of Southwestern Public Service Company.
All right. And does this testimony have any attachments to it?
It did, but the attachment was excluded.
Why is that?
Per feedback from the hearing examiner during, I believe, the pre-hearing meetings.
Okay. Was this testimony prepared by you or under your direct supervision?
Yes, sir.
And if you were asked the same questions today, would your answers be the same?
Yes, sir.
And are those answers true and correct?
Yes, sir.
Your Honor, I move for admission of SPS Exhibit 23.
Any objection to what's been identified as SPS Exhibit 23? Mr. Cooley's rebuttal testimony as provided in the Dropbox. Hearing no objection, SPS Exhibit 23 is admitted. Mr. Moss?
Thank you, Your Honor. SPS now tenders Mr. Cooley for the hearing examiner's questions.
Thank you. Just would like the record. Good morning, Commissioner. Like the record to reflect that Commissioner Ellison has joined us. Commissioner, we are getting ready I have a few questions for SPS witness Cooley. I do not believe that anyone reserved any time for examination of Mr. Cooley. And as I indicated, I believe I have a few questions for him. And I guess, Mr. Cooley, welcome. I just wanted to briefly try to understand your role with for SPS and what your job duties entail as they relate to the rate case here. So I note that you are the Director of Strategic Planning for SPS, and you indicate in SPS 21 that your responsibility is for leading and directing Xcel Energy-wide teams to plan and implement business projects for SPS. So can you, you go on to say in that role you work with generation and transmission planning teams, and you coordinate with the Southwest Power Pool or SPP on regional policy and allocation issues. So since you're actually an SPS and not an Xcel employee, what kind of interaction do you have with in your role as leading and directing Xcel Energy-wide or energy-wide teams?
Yes, good morning, hearing examiners. Pleasure to be here this morning. So as you read out, that I put in my direct testimony, my role is strategic planning. Within Xcel Energy, we have a large number of employees that are part of what is called the Xcel Energy Services part of the company. And those employees are within the engineering teams of transmission. They could be resource planning. There could be individuals that are on our tariff administration teams, and they may be based in SPS's service territory, or they may be based in other portions of the Xcel Energy region, which would include Minnesota or in Denver. And so part of my role is to collaborate with those groups, focused on SPS efforts, but bringing in those subject matter experts on their specific policies or topics and helping them craft or work on different items that are impactful to the SPS service area. A prime, sorry.
Go ahead, sir.
A prime example that I would have is we have a federal regulatory affairs team that helps assist Xcel Energy wide. They have individuals based in Minneapolis, Denver, and in Amarillo. One of the key counterparts that I work with who focuses on SPP policy and the tariff at SPP, he is actually based in Minnesota, and he's an Xcel Energy Services employee. And so that's what it means by working with, leading, and directing those individuals who fall underneath the Xcel Energy umbrella, but bringing them and focusing on SPS specific topics.
Do you, with part of your job responsibility and the collaboration with, for example, the individuals that you've just met, are you solely responsible for SPS's interactions with the SPP, or do you also provide any direction for any of the other, are any of the other Excel subsidiaries part of SPP?
No, currently SPS is the only current member of the SPP from the RTO perspective, the regional transmission operator perspective. The Public Service of Colorado is investigating efforts, and they are currently part of the Western Integrated System. They're part of the WISE market, but that is a completely separate subset from my interactions with SPP.
Can you
That's purely Western markets.
Can you spell WISE?
WEIS.
And what is that an acronym for, sir?
Western Energy Imbalance System.
And
so I do not represent Xcel Energy. I only represent SPS at the SPP meetings.
And as part of your direct testimony, as set forth in Exhibit 21, it's not free to belong to SPP, is it?
No, ma'am.
And as a matter of fact, beginning on page 12 of your direct testimony, you've indicated that the schedules and the amounts that SPS is requesting to collect in SPP expenses on a New Mexico basis, approximately $4.8 million. Is that correct? Page 14, Mr. Cooley.
Yes, ma'am, that is correct. Table JJC1 on page 14.
And can you just, for the record, give a brief description of what the ratepayers get for $4.8 million from SPP?
Yes, ma'am, I can definitely do that. Going back on page 10 of my direct testimony, I do talk about some of the benefits that SPS's customers obtain by being a member of SPP. One of the largest benefits is having access to a larger pool of resources from the market perspective and allowing lower cost energy to be used to serve SPS customer load. An additional item is the amount of generation reserves that we need to have. If we're operating as our own balancing authority, we will likely have a significantly higher amount of generation that we would need to have in reserve for possible outages. Being able to leverage our ties and being a partnership of SPP allows us to have that at a lower value. Additionally, SPP has collaborative transmission planning processes. They also have outage coordination. They also do some of the compliance burden that is taken away from SPS and Xcel Energy employees. And additionally, SPP manages the generation interconnection queue, which is a very large and complicated and time-intensive process.
Well, and to that particular benefit, it's kind of a double-edged sword, isn't it, Mr. Cooley? In that with participation comes responsibility and potential penalty if one does not meet the responsibilities that have been assigned by SPP, correct?
That is correct. That is the case, notwithstanding our membership with SPP. There's a lot of requirements set forth by NERC that have fines tied to those. And so SPP helps us deliver on some of those requirements. And so there are, yes, there are negatives. There could be consequences. However, we do have a very active and strong presence within SPP. We have a large number of people who participate in different working groups and follow the different policies. And we do a very good job of taking care of what needs to be done to avoid those type of penalties.
Who makes the ultimate decision at SPP?
So it really depends on the topic. There are certain items at SPP that are taken care of primarily by what we call the working group level. If we go to my attachment JJC2, I kind of have an outline of the organizational chart of SPP. This is not all encompassing, but it does highlight a lot of the different organizational structures. And
so for example,
yes,
let me just, pardon me, let me just direct you to a question that I had that relates to prior testimony that I have read in the case. My understanding is that SPP in its accreditation process / decision is lowering the attributed capacity to certain renewable resources like Hale and Sagamore. Are you familiar with that?
I am familiar with those discussions.
And if the accredited capacity is lowered by SPP, that potentially can affect how much generation that SPS is going to have, correct?
How much generation SPS will have to meet the planning reserve margin? That is correct.
Well, the planning reserve margin or to not only meet the planning reserve margin, but to actually serve their customers, right? Well, let's just say in terms of the planning reserve margin for now. So that could be a negative of belonging to SPP, right?
It could be, yes. What also though is that the process, and Ben Elsey can also speak on this as he is a member of what is called the Supply Adequacy Working Group at SPP. He is the SPS representative on that committee who focuses in on the allocation discussion. The positive that can be is that maybe we're overcounting the accredited capacity of certain resources that cannot actually be counted on during certain situations. And so doing overcounting certain accredited resources towards your capacity could actually cause us to have issues during certain events, which could result in a blackout or a shortage of energy. And so, and that could also result in load shed events. And so the idea of making sure we find the right fit for those accreditations is very important and is a very, it's an ongoing discussion right now at SPP of making sure we find that right percentages for the different resources to count for accredited capacity.
Well, and again, I'm just trying to figure out how much, you know, how much input, final decision-making control does SPS have when these kind of decisions are made within the SPP?
Yeah, so I can elaborate a little bit more on that. So looking at the middle of the screen in that kind of that blue square, there's the supply adequacy working group. That feeds into what is called the Market and Operations Policy Committee, which has a representative from every single member of SPP. There's 114 different entities that are members of SPP. They span from investor-owned utilities to cooperatives, municipals. And so a vote at the Supply Adequacy Working Group will then feed into a vote at the Market Operations Policy Committee. And then in regards to this topic in particular, a vote will then also go to the SPP Independent Board of Directors. Now, and the Board of Directors also has a non-binding vote from a members committee rep. So the members committee is actually it's a subset of different sectors within SPP. SPS President Adrian Rodriguez is actually on that members committee, and I sit on the Market and Operations Policy Committee. So from the most technical to all the way to the Board of Directors, SPP leadership has opportunities to hear from us multiple times in multiple different forums. In regards to resource adequacy, though, I do want to highlight that the Regional State Committee is actually the point for resource adequacy at SPP. And the Regional State Committee is highlighted over there on the left side in orange. The Regional State Committee is actually comprised of a commissioner from every state in SPP. So all 14 states have a single representative on the Regional State Committee. For New Mexico, that is Chair O'Connell. He is on the RSC. And then the Cost Allocation Working Group, which feeds into the Regional State Committee, Mark Tupler from the PRC staff is on that committee representing New Mexico. Now, all topics tied to resource adequacy not only go through the Supply Adequacy Working Group and then the Markets and Operations Policy Committee, they also go through the Cost Allocation Working Group and the Regional State Committee. And so I do want to highlight it's not just SPS having a voice in resource adequacy conversations. We also have the state of New Mexico has a very strong opportunity to also weigh in on behalf of New Mexico customers.
And I'm assuming that within this structure and the dynamics of the way that the different parts work, that there are not only input and contribution opportunities, but there's also procedures to challenge.
Yes, ma'am.
Some decision that's made.
Yes, ma'am. Depending on what is the outcome, it could be a challenge to the SPP tariff. It could be a challenge to the FERC filing itself. In regards to changes to allocation for renewables, and again, Mr. Elsey can speak on this as well. That does require a FERC filing. And so there are opportunities if you're not happy with the outcome through the stakeholder process at SPP, there could be a challenge at FERC.
Is there also an opportunity to challenge any of the costs that are assessed to the member entities?
Yes, ma'am. So trying to see. On the left side of this table, again, halfway down, there's a committee called the Finance Committee. It is overseen by by one of the members of the Board of Directors, but it does have stakeholder inputs. That Finance Committee does oversee SPP's budget on an annual basis and sees what the charges are likely to be and how much sales megawatt sales are happening. And there's an opportunity there to push back on SPP if there is if they're putting too many bells and whistles within SPP, there's an opportunity to challenge them there. And then anything from the finance committee also goes up to the board of directors, where people are allowed to also give inputs. So there are opportunities to challenge some of those administrative fees from SPP, both within the working group as well more publicly at the board of directors.
And within the determinations that SPP makes on SPS's system, whether it be system adequacy or system generation, offerings, and calculation of market price, does SPS have an opportunity to participate in those decisions made by SPP?
In regards to what is offered in for generators, that is something that we do in SPP and the market monitor take our offerings and then they implement that as part of the market. So all those values go in. Now, how does the market clear? And did it clear as we expected? Now that is an opportunity. We can supply input or questions to that, yes. If we feel that something is happening that we didn't expect or thought should have happened differently, there are opportunities to challenge that, yes.
Okay, and if, you know, I mean, aren't there actual evaluations by SPP on the adequacy of the SPS system as it relates to its obligations under the SPP?
So, Madam Hearing Member, I'd like a little clarification on, are you talking from a market perspective or from a resource adequacy and capacity perspective?
Oh, yeah, I'm talking about from a technical operational perspective.
From an operational perspective, SPP is a regional transmission operator and has oversights into all the grids that are part of SPP. And so they are tied in directly with how we operate our system. Again, generation outages and transmission outages are cleared through the SPP, not by SPS. And so those are requested. Our SPS team does work to file those, but it is, at the end of the day, it is cleared by SPP. So
I guess what I'm trying to think more on a technical nature, Mr. Cooley. So for example, I seem to recall back in the Hale and Sagamore CCN case that potentially part of the costs were going to be upgrades to certain transmission and other types of facilities in order to be able to incorporate the energy from Hale and Sagamore into and the SPP purview. Is that correct?
That is correct, Madam Hearing Member.
And it was kind of pricey. I mean, it seemed like that these upgrades that were being I don't want to say demanded by SPP, but that were being required by SPP. It seemed to me that the SPP has a certain amount of control over costs that are incurred by SPS that relate to generation resources. Is that correct?
So in regards to Hale and Sagamore, they were went through the generation interconnection queue, which is managed by SPP. And so
I'm sorry, they both went through the
generation interconnection queue that is managed by SPP. And so that study process does identify necessary network upgrades to interconnect new generation, whether it's wind, solar, gas, even batteries going forward. And so those network upgrades were per the generation interconnection process, the manual, and the study parameters outlined. That is consistently applied across all generation and all parts of SPP. Those were the network upgrades that were identified as needed to connect that generation to the SPS system and not harm the existing generation or load serving characteristics of the system. And so in regards to Sagamore, that was a 522 megawatt wind farm. There were network upgrades to avoid overloads during different contingencies and different generation patterns. So I would say, circling back on those network upgrades, we believe that those were necessary and prudent, and that's why we moved forward through, I think, the previous rate case to put the generation as well as the network upgrades in service.
Okay, and again, I guess I'm just trying to understand how much control over the purse strings that SPP has in your generation planning, Mr. Cooley.
So obviously, again, I don't want to point it as SPPs, but it's the policies that SPP implements on behalf of all the stakeholders is really where it comes down to. There is obviously a lot of I guess opportunities in there for costs to come forward. Now, the generation interconnection queue is a very complicated item. I'll be honest that there's actually been a task force that's been working for the past year and a half to really create and document every single step of the generation interconnection study process, because there's a lot that goes into it. And so and what that has is there's different thresholds that trigger network upgrades. There's different percentages of which resources are being dispatched in the base models. There's different generators that are even included in the models. And so how all that goes together is actually discussed publicly in stakeholder forums. Obviously, there's a lot of different opinions on how much generation or how much load should be included because it drives different outcomes. Some of the concerns are if you don't address enough network upgrades up front, you're going to run into congestion issues down the road, which will result in higher energy prices and possibly new transmission projects that are paid for by the transmission owner. Versus if you capture more projects up front, that'll be paid for more on the generation owner side. In regards to sometimes third-party generation or PPAs, the dollars definitely moves around a lot. And so there's obviously different voices advocating for different positions. At the end of the day, there's a set policy that everybody has to live with, and you are allowed to challenge said policy. Whether you get traction enough to get votes to change those, that's a different story. But from our standpoint on the SPS side, is we are very active in those conversations to make sure costs are being allocated to the right parties, to the best of our abilities to make that happen.
Mr. Cooley, as part of your job responsibilities as being the director of strategic planning, are you also part of generation planning?
Yes, ma'am. I participate and help engage in those discussions on where we want to go and how we can get there in regards to the future of our generation fleet.
And is that is that an internal discussion within SPS?
We do have internal discussions, but as I do want to refer back to, I believe, Brooke Trammell's discussion with you, we are part of the integrated resource plan as laid out by the state of New Mexico. And that is an open forum for discussions on future generation resources to the SPS system. So
Right, and I guess I was trying to, the way I phrased it, I was just trying to figure out if you're talking about that's looked at within SPS, or is that looked at an Excel level or both? And does that, well, I'll wait on the next part of the question, but.
the answer is yes, it is SPS, but it is also an Excel Energy wide discussion because it does influence, again, some of those Excel Energy services employees, as well as our annual capital budgets that do feed up to the overall Excel Energy umbrella.
And does this translate these discussions and potential scenarios? Does it translate into any discussions or committee at SPP?
In regards to our future generation portfolio?
Well, yes.
So there are discussions in some of the economic models that the transmission planning organization runs. There are what we call future scenarios. And within those future scenarios, there are sensitivities around coal and gas retirements. And then what would subsequent new solar, wind, battery solutions look like? And where would those be placed? We do participate in those conversations to help kind of give an insight into where we would think per the queue and other item factors of where future generation would be cited. And then we look at how would that future generation interact economically with the existing load and other contingency analysis. So there, it is a little bit, but until we get final approvals, we do not pull generation out of the models and we do not place new generation in until we do have approvals as part of the typical transmission planning or transmission planning analysis in particular.
Yeah, and I guess I just wondered in terms of future planning, if there's like a discussion on a broader level, like the level of SPP, where they look at particular service areas or particular generation compositions, and there's a discussion that says, oh, well, that one area is really constrained. There's not going to be any way that we can move more any more energy into that particular area. And oh, by the way, X company, you've got 15 coal plants, and you're going to reach a point in time where maybe you're going to have to get rid of those and get some wind or some solar. If there's those kind of actually either service area or company I don't want to say a review, but a discussion.
So in regards to generation itself, one of the SPP's responsibilities is not generation planning. That is not one of their responsibilities. And so they manage the queue as an independent third party. But and on the flip side of that, I will say that when you look at the results of the generation interconnection queue, you can find some more constrained areas that drive more network upgrades than others areas within SPP. And so you could derive some of those, as well as annually SPP does the state of the market report, and that identifies constraints, frequently constrained areas for the last year, which then could also identify areas that are constrained more in real time, not forward looking, but historically. And that could also help drive some of those conversations or insights. But again, SPP itself is not pick and choose where generation should be going, and they did not plan that. It's a conversation, but that is not one of their responsibilities.
Okay, I mean, their bottom line in managing the distribution of the energy is only concerned with or primarily concerned with the characteristics of the generation itself, of how much can I get and when can I get it and how much does it cost? Is that right?
Can you please repeat that?
Sure. You're saying that they're not involved in the planning, and you're saying that, you know, when they're managing the queue, it's pretty much not type of generation specific. It's more related to the amount of energy that can be produced, when it can be produced, and how much it's going to cost.
Yes, ma'am. I will add in there that there are a lot of discussions around resource adequacy, especially following Winter Storm Uri. So there's a lot of discussions on what is the right portfolio. And as we move forward, we've been starting to see some discussions that SPP points out as challenges on either low wind days or days in which there's been a lot of outages for generation. And so they've been highlighting some of these issues. And then some of these conversations do feed into the discussions that drive the planning reserve margin. So again, they don't pick specific units, they're not picking on specific areas, but from a holistic view, they are very concerned about the transition of the grid and making sure there's enough adequate capacity on the system for certain events. And so again, that I would tie that back to some of the working groups efforts and the detailed technical studies. But SPP is very concerned about, from a holistic view, the amount of wind and solar in conjunction with the retirements of coal and gas, and what does that system look like, and what does the right planning reserve margin, what is the right ramping capabilities, what is the right inertia needed on the systems to keep the lights on. That is the goal at the end of the day, to keep the lights on. And that is a stakeholder driven process that is open, transparent. It is discussed in multiple venues of trying to find what is the right values for those different inputs.
Okay. Very well, sir. That's the questions that I have for you. Mr. Moss, any redirect for your witness?
Yeah, just briefly, Your Honor. Particularly, how many SPP members did you say there are?
I believe there are 114 members of SPP.
Okay, and is membership in an RTO like SPP, is that voluntary, or do they have to join?
There was a FERC order for transmission utilities to join an RTO. Now, there are a large number of utilities out west who are not part of an RTO, but I'll just leave it at that.
Well, do you think that the 114 members of SPP would remain in the SPP if they didn't see a benefit to being an SPP?
No, if they did not see a benefit, they would not participate.
Okay, let me direct you back to page 10 of your testimony where the hearing examiner was asking you about that, of your direct testimony. Let me know when you're there. So line 3, you testified, excuse me, SPS's customers benefit by having access to a larger pool of generation resources as part of the Southwest Power Pool's integrated marketplace, allowing low-cost generation to serve SPS's load. Do you see that?
Yes, sir.
If SPS was not a member of the Southwest Power Pool integrated marketplace, how would it have to operate differently?
We'd have to rely solely on SPS generation, or we would have to contract with entities within SPP or to the west across different tie lines, which would have a significantly different pricing resulting around those. Instead of being part of SPP, it's just part of a pool in which it's picked accordingly to the market, as well as any regional reliability issues as the low cost options.
Okay, and maybe you know this, maybe you don't, but has SPS or anyone else ever quantified what this benefit is on an annual basis?
I don't have that. I believe that when we joined the SPP marketplace in 2014, we did do a quantification of the benefits, but we have not done that previously, to the best of my knowledge.
Okay, moving on to line 5, you say, additionally, SPS is able to decrease the amount of generation reserves needed in the event of a certain sudden resource outage because it is part of a reserve sharing arrangement. What would be the effect on SPS's generation reserves if it was not a member of Southwest Power Pool?
It is my opinion that we would have a much higher planning reserve margin, much higher than the 15%, to take into account different generation outages, forced outages, wind and solar unavailability during different times of the day or the year. So we'd probably require to have significantly higher amount of generation serving SPS load.
And how would that affect?
But you might not be able to collect for a significant increase in your reserve margin. Might you not, Mr. Cooley?
I believe that we would have to do very detailed studies to identify this, which we do not know that number today. But it would definitely, especially as we transition to more renewable based, figuring out what is the right technology to make sure that at the end of the day, we can keep the lights on during a wide number of contingencies, during winter, during summer, during off peak, that we would be subjected to if we were not part of the wider SPP pool.
But there is such a thing as excess capacity, correct?
Yes, ma'am. But the point of excess capacity is to allow you those opportunities for things that go wrong that you don't plan for.
Thank you. Go ahead, Mr. Moss.
The last sentence on that answer says, finally, Southwest Power Pool is responsible for overseeing transmission planning studies, the generation interconnection queue, transmission service requests, load interconnection requests, and outage coordination. Did I read that correctly?
Yes, sir.
If Southwest Power Pool did not do those things, would SPS have to do it themselves?
SPS or using our Xcel Energy Services employees. Yes, sir.
Okay. One last question. Madam Hearing Examiner asked you about, isn't there some penalties associated with being in Southwest Power Pool? You're subject to penalties. Do you recall that?
Yes, sir.
And you said that some of those penalties are actually assessed by NERC. Is that correct?
Yes, sir.
For the record, what is NERC?
North American Electric Corporation.
Is that a state or federal organization?
It is a federal organization underneath of, yeah, it's federal.
Okay. If SPS was not a member of Southwest Power Pool, would it still be subject to NERC penalties?
If we were found to be non-compliant to the NERC standards and NERC orders, yes.
Okay. Thank you, Madam Hearing Examiner. Those are all the redirect questions I have.
Thank you, Mr. Moss. Mr. Cooley, prior to joining SPP, Wasn't SPS part of a different RTO? Or was it?
I believe SPS has been a member of SPP for a very long time. And SPP did not, I forget when exactly SPP became an RTO, but I believe SPS is one of the first members when SPP became an RTO.
Okay. Do you know, I mean, was SPS part of any other regional type group?
I cannot, I don't know the answer to that, ma'am.
Okay. So you don't know if it was ever part of ERCOT?
I can tell you that SPS has never been a member of ERCOT.
Okay. Thank you. All right. Anyone have any more questions for Mr. Cooley? Hearing none. Thank you so much, Mr. Cooley. You are excused, sir.
Thank you, ma'am.
All right. I believe we're getting pretty close to the luncheon hour. So I think that unless there's an objection, I think we'll recess for lunch and come back at 1. And Mr. Moss will, Mr. DeAscendis be available at 1.
Yes, Your Honor, that's my understanding that he will.
Very well. Let's recess until 1, and then SPS can present SPS witness, Mr. DeAscendis. Again, just to remind you all, the YouTube's going to stay on, so please acknowledge accordingly. Thank you.
Hello, I just wanted to test my video and my microphone.
Yes, sir, I can hear you fine.
Awesome, thank you.
Mr. Lee,
Yes, ma'am.
hi, this is Sydney. What time did Ms. Hurst say she was? Oh, there she is. Are we resuming now at 1 o'clock?
Yes, ma'am.
All right, thank you.
Well, I guess I could just keep talking, being muted. Some people might prefer that. But we're back from our luncheon recess. And I wondered if anyone had any updates regarding witness availability. Particularly interested, Mr. Gatko and Dr. Woolridge.
Yeah, I communicated with Dr. Woolridge. He's traveling on Monday and Tuesday, and so that confirmed that it would be very wonderful if we can do 1st a.m. on Friday with Dr. Woolridge.
Unfortunately, that's not a possibility. I've been informed that one of the commissioners is not going to be available until 1 on Friday.
Okay. Shoot. And, you know, another option that was presented was before 10 a.m. on Monday, but I don't think that gives enough time, was my guess. And so I shot that down on my end. Do you think that's a fair assessment, or would that be something to consider?
Unfortunately, I have a unmovable conflict Monday morning, and our hearing on Monday is not going to start until 11.
Okay.
I tried and tried, but I can't get rid of the conflict. So we're going to have to start late. I apologize in advance to everyone for that. So perhaps you can keep working with Dr. Woolrich. Like I say,
1 p.m. on Friday is the goal there.
I mean, we could try to have an early lunch, and we could, try for, 12:30 is probably the earliest I could do.
Okay, I'll get
right.
on the horn again. All right, thank you.
All right, thank you, sir. And I'm considering just my own proposal, depending on the feedback I get. I'm considering having witnesses, Crane and Glick appear tomorrow, beginning at 9. But I don't know the commissioner's availability yet, so I'll keep you informed. Okay, with that, I believe, Mr. Lee, would you like to swear the witness, sir?
Yes, ma'am. Mr. DeSantis, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not pending to be the truth, the whole truth, and nothing but the truth?
I do.
I thank you, sir.
Thank you, Mr. Lee.
And Madam Hearing Examiner, Jeffrey Stewart for SPS. I'll be presenting Mr. DeSantis.
Very well. I thought, Mr. Moss, you've changed. Go ahead, Mr. Stewart.
Mr. DeSantis, could you please state your name for the record?
Sure, it's Dylan, D-Y-L-A-N, DeSantis, D''A-S-C-E-N-D-I-S.
And by whom are you employed and in what capacity?
I'm a partner at Scott Madden, Inc.
And do you have in front of you what has been marked as
Sorry,
SP?
I'm employed by Scott
Madden, Inc. It's S-C-O-T-T, capital M-A-D-D-E-N. It's all one word.
Thank you, sir.
Yes.
Do you have in front of you what has been marked as SPS Exhibit 16?
I do.
And could you identify that document for me?
It's my direct testimony and exhibits.
And are there any attachments to that testimony?
So there is one, and it consists of 12 schedules.
All right. And was that testimony and its attachments prepared by you or under your direct supervision?
Yes.
And is it true and correct to the best of your knowledge?
Yes, sir.
Madam Hearing Examiner, at this time, I'd move for the admission of what has been marked as SPS Exhibit 16.
Mr. DeSantis, welcome.
Hi, how are you?
I'm all right. Yourself?
Good.
Good. If you were asked the same questions today as you were in this particular piece of testimony, would your answers be the same?
Yes.
And they're true and correct to the best of your knowledge?
Yes.
And Mr. Stewart, this 176-page document identified as SPS Exhibit 16 is, and placed in the Dropbox, is the document that you're offering. Is that correct?
That is correct.
Any objection to what's been identified as SPS Exhibit 16? Mr. DeSantis' direct testimony. Hearing no objection, SPS 16 is admitted. Mr. Stewart?
Mr. DeSantis, do you also have in front of you what has been marked as SPS Exhibit 17?
Yes.
And could you identify that document for me?
That's my supplemental testimony.
And does your supplemental testimony have any attachments? sorry, does your supplemental testimony have any attachments? Sorry if you didn't hear me.
I said no. I didn't know if you heard me.
I didn't hear you. Okay. Was that testimony prepared by you or under your direct supervision?
Yes.
And if I were to ask you the same questions contained in that testimony today, would your answers remain the same?
Yes.
Madam Hearing Examiner, at this time, I'd move for the admission of what has been marked as SPS Exhibit 17.
Any objection to what's been identified as SPS Exhibit 17, Mr. Diascendis supplemental testimony? Hearing no objection, SPS 17 is admitted.
Mr. Diascendis, do you also have what in front of you what has been marked as SPS Exhibit 18?
Yes.
And could you identify that document for me?
Is my rebuttal testimony.
And are there any attachments to your rebuttal testimony?
There's one attachment and it consists of 19 schedules.
And was this testimony and the attachment prepared by you or under your direct supervision?
Yes.
And if I were to ask you the same questions today that are contained in your rebuttal testimony, would your answers remain the same?
They would.
Madam Hearing Examiner, at this time, I'd move for the admission of SPS Exhibit 18.
And SPS Exhibit 18 is a 289-page document placed in the Dropbox, identified as Mr. Diascendis rebuttal testimony. Are there any objections to the introduction of SPS Exhibit 18? Hearing none, SPS Exhibit 18 is admitted. Mr. Stewart?
Mr. Diascendis, do you have what has been marked as Exhibit SPS 19?
I do.
And could you identify that document for me?
That is my testimony in support of the contested comprehensive stipulation.
And are there any attachments to that testimony?
No.
And if I were to ask you the same questions today that are contained in that testimony, would your answers remain the same?
Yes.
Madam Hearing Examiner, at this time, I'd move for the admission of Exhibit SPS 19.
Any objection to what's been identified as SPS Exhibit 19? Mr. Diascendis testimony in support of the stipulation, 16 pages as put into the Dropbox by SPS. Hearing no objection, SPS 19 is admitted. Mr. Stewart?
I would tender the witness for questioning.
Thank you. I believe that based upon my review of the pre-hearing memos, none of the parties in this case have any questions or have reserved any time for Mr. Diascendis. Therefore, we'll proceed with questions from the commission. Commissioner Ellison, you have questions for Mr. Diascendis, sir.
Yes, I do.
Thank you, sir.
Shall I proceed?
Yes, sir.
Great, thank you. Thank you for appearing, Mr. Diascendis, before us today. Should the approved ROE equal the cost of equity?
Yes.
Okay. So I guess looking at your testimony on page 5, table 1, I see several different models and methods used to estimate the cost of equity. And then I see, looks like line 5, a range of equity cost rates, with the midpoint being 10.85. Is that correct?
That's right, sir.
Okay. So how did you arrive at that midpoint, based on those previous 4 calculated values?
Sure. So I take the midpoint of the high and low range of those 4. And then I take the midpoint and then I apply 50 basis points to the top and bottom. So if you take I'll do it with you. You take that 873 plus 12.74. 2.
So again, you're just averaging the 9.2, 11.72, 11.81, 12.74. Is that correct?
No, I'm not taking the average, sir. I'm taking, if you take a look at, it's the average of the 873 of my traditional DCF model on page 1 of Schedule 3. I average that with the 9.2% New Mexico based. You could see that on the, sorry, I'm pointing at something that, so you see that, footnote 4, you see that 8.96 there, which is the average of the way that I usually do the DCF approach with the New Mexico DCF approach.
Yes, I see that number, 8.96.
So if you take an average between that and 1274, that midpoint is 1085.
Here, are you saying D as in David, C as in cat, F as in Frank?
Yes, sir. It's an abbreviation for discounted cash flow model.
Thank you, sir.
Yeah. So Mr. Commissioner, if you do that 8.96, you add 12.74, that's the range I use. And then the midpoint of that range is 1085. And then from that midpoint, I add and I put my range is 50 basis points above and below that midpoint.
I see. Okay, thank you. That's helpful. It just wasn't immediately obvious to me in reading through your testimony what you did with those first 4 numbers to get that 10.85 midpoint, but I appreciate your explanation. Let's see. I wanted to ask about something you have on page 45 of your testimony.
This is direct testimony?
Your direct testimony, yes.
Yeah.
So you're asserting here that the constant growth DCF model has consistently produced results below authorized returns. Is that correct?
Yes, sir. And it would be an example of how commissions would be considered to get to their authorized returns. They must have also considered other model results. So I'm not saying that the DCF is a model that shouldn't be relied upon. I'm just saying that from the data, it is inferred that the commissions use other models besides the DCF in determining their ROE.
Is it fair to say that the constant growth DCF model is a commonly used and accepted method for calculating the cost of equity?
Yes, sir, I'd agree with that.
What is the source of your chart 5 on that page 45?
So if you look at that footnote 34, it's based on quarterly average stock prices, EPS growth rates from Value Line, Zacks, and First Call.
I'm sorry, EPS?
Yeah, EPS, I'm sorry, earnings per share growth rates, which would be long for EPS from Value Line, Zacks, First Call, and Bloomberg. And then the authorized ROEs, which is return on equity, are quarterly average for vertically integrated electric utilities. So we use prices from Bloomberg and then the various sources of growth rates, and they should be all provided to the parties in discovery. And then all of the other data for the authorized returns were from the Regulatory Research Associates, or RRA.
And so this chart, this data is something that you have calculated at least the mean DCF results.
Yes, sir.
Is this something that you have published in a peer review journal, these results?
No, sir. What we're looking at here is that the DCF alone shouldn't be relied upon solely to determine ROEs, and in fact that they have not been. So it's more about using multiple models to estimate the cost of capital rather than the efficacy of a certain model.
Yes, I understand. The data that you used for these calculations, have they been provided to the PRC?
Yes, they should be in my work papers. And they were for sure on the share file, I think on the share file website.
Okay. Could it be that the cost of equity estimates produced by the constant growth DCF model are unbiased, reasonable, but that the approved ROEs are higher than the true cost of equity?
No, I don't agree with that. I think that investors use all, and this is all a part of the efficient market hypothesis, or the EMH. And what that hypothesis states is that investors use all relevant information to make investment decisions. And since the DCF is not the only ROE model out there, and frankly, that's the only one that I use that's not based on Nobel Prize winning work. So if you look at the CAPM, that's based on Nobel Prize winning work. If you look at the PRPM, that's based on Nobel Prize winning work. So if you're an investor and you adhere to the efficient market hypothesis, you would want to look at a robust data set, and that would include, and I'm not saying exclude the DCF, I'm saying that the investors would look at the DCF results in concert with the CAPM and the risk premium and also models, or also indicated ROEs for companies that are deemed to have comparable risk to utility companies. So I don't think that the true cost of equity is represented by any one model, and that's the judgment that the analyst has to make in looking at the results of those models.
Well, I guess I'm not asking about investors' viewpoints or the efficient market hypothesis. I'm asking about what regulatory commissions have approved, which is something different. And I'm simply asking whether it could be the case that for whatever reason, the ROEs approved by utility commissions, could they be higher than the true cost of equity?
So that would violate the commission's mandate to set. I mean, I'm not a lawyer, but it would violate the commission's mandate to set just and reasonable rates based on the cost of equity. So if there was something where a commission is now, settlements are different because they're like the ones that we're at. It's a full package with negotiations and things like that. But when you're looking at ROEs set by commissions, every single one of those cases includes a discussion on ROE from various stakeholder viewpoints. And the commission takes those data points and then makes a decision on what they think is the investor required return for an investment in that company. And that decision is based on those models. So I don't think that commissions are setting rates of returns that don't reflect the true ROE, because by definition, the authorized return is the true ROE.
Well, the authorized return is the authorized ROE, but it may or may not be the cost of equity. Obviously, there's judgment. No commission intends to set rates that are different from those that are just and reasonable, but obviously there is judgment involved in figuring out what the cost of equity is, and there could be reasons why commissions have consistently awarded ROEs that are above the true cost of equity. Are you aware of the Werner and Jarvis study from 2022 that is cited by the Attorney General's witness?
Yes, but I want to disagree with what you said before your question, and the commission is using their judgment to set the ROE, which is based on market models as presented by the various witnesses in this case. There isn't they choose from the data on the record, and it has to be bound by what has been provided by these witnesses on on the record in the case for cost of equity. It's not, oh, well, everybody's requesting 10%, let's say, and we're just going to authorize a return of 12%. Commissions routinely in their orders discuss the models that were presented and what the commission's weight that they put on the various models. So for you to say that they're using their own judgment, I agree based on the experts' opinions based on ROE. As far as this document, I have reviewed it, but it is one of, if you take, and I have a different copy in my library. What it says is that it's a working paper, and it says that it hasn't been peer reviewed, nor has it been subject to review by any editorial board. So from what this Werner and Jarvis is that it's not a peer, it's because it's not peer reviewed, because it's not reviewed by an editorial board, it's simply an opinion piece.
Well, it's something that has been circulated widely and is available for critique. And my understanding is that it indicates that essentially regulators have historically responded faster to increases in the cost of capital than they have decreases, so that you have kind of a stickiness of approved ROEs as compared with what would be calculated by market models. So you know, I would really question the assertion that approved ROEs are by definition the cost of equity. They are an attempt to approximate the cost of equity, but they may fall short in that attempt, and there may be some inherent biases. That's at least my interpretation. Another question here is that, you know, in that chart, chart 5 on page 45, you know, you've compared it with constant growth DCF calculations. Have you compared the other models used in your analysis with historically approved ROEs?
I have not, but I wanted to get back to the Werner and Jarvis paper and the conclusions that they spoke of. And I wanted to point you to page 58 of my rebuttal testimony. And it discusses, and the point that I'm talking about is that authorized returns haven't moved with interest rates. And when you look at, and I'll wait until, I guess, whoever, Your Honor, gets to page 58 of my rebuttal testimony, but current interest rates are around 3.75%. The last time that interest rates were at this level, authorized returns were at 10%, in excess of 10%. In this case, the parties agreed to a 9.50%, which is significantly less than what was at the last time in this case, the last time interest rates were this high. So when Werner and Jarvis talk about interest rates or ROEs being sticky on the way down, they are also sticky on the way up. And the reason why it is sticky on the way up is because there's an inverse relationship between interest rates and equity risk premium. So, and that inverse relationship isn't a 1-for-1. And because of that, as interest rates move, say 100 basis points, the cost of equity moves 50 basis points. So while they're saying that that authorized ROEs have been sticky, they're sticky in both directions. And that's something that I think Werner and Jarvis, and since it's not a piece of academic literature and you have to hunt this thing down to get it, I wouldn't say that this is an authoritative document at all. But they have only talked about one side of the story.
So I think risk-free rates have been coming down for a long time. If you think about, from the early 80s, they were at all-time highs, and they've been really coming down a long time. And so I'm not sure there's that much experience with them going up. My impression was that the authors argued that they were sticky on the way down and not so sticky on the way up. There is another study, Road and Fishback, from 2019, which I believe is a published study, which comes to similar conclusions. But I wanted to get back to this, the question that I just had about the fact that you compared the constant growth DCF model with historical ROEs, yet you did not make that comparison with the other models you used, and I'm wondering why not. So, if you would check for some alleged bias in one model, why wouldn't you check for it in other models?
So DCF's a pretty straightforward calculation where you can basically do dividend yield. There's only a couple ways to do dividend yield. There's only a couple of ways to do growth rates. And since you're only looking at those two inputs, it's very easy to use and backcast that data. When you're going to determine or use a CAPM model, you can see just within all of the intervening witnesses in this case, betas are an issue. There's not a agreed upon beta to use. There's not an agreed upon risk-free rate to use. There's not an agreed upon market risk premium to use. So for the CAPM generally, it would be very hard to have something track authorized returns that would be accepted by commissions and other parties. So, I think that's one of the issues with that Road and Fishback article too, because they strictly use the CAPM, and there's several different ways to calculate one. So I mean, there's a lot of things where, and then risk premium is the same thing. There's so many different ways to put together a risk premium, whether to apply it to a risk-free rate or a utility bond yield. So there's a lot of different moving parts in risk premiums and capital asset pricing models.
I'm sorry, premiums and
capital asset pricing models.
Well, Mr. Diascendis, there appears to be a wide range of implementations of all of these models. Hence, we're getting quite differing results here in these testimonies. Even the dividend discount model, there are issues with the growth rate that is assumed, and if you're using, Wall Street analyst 3 to 5 year growth rates, which I understand is what you're relying on here, then isn't there a fair amount of controversy around whether how accurate Wall Street analysts are?
So I guess I'm going to go back to what you said about the intervening parties. If you take a look at all of the DCF models put forth by the companies, or all the interveners except for Mr. Garrett, which I have particular disagreements with in his application of the DCF, you'll see that Mr. Tupler, you'll see that Dr. Woolridge, you'll see that Mr. Walters all used dividend DCF model using analyst growth rates. You will see that. So as it being a controversy, there might be differences of opinion based on biases, but 3 out of the 4 witnesses used analyst EPS growth rates for their DCF to inform their DCF model results. So that's why you can use that data in chart 5 in my direct testimony, and why you can't do the same analysis for the other folks.
Well, I mean, what you've done with chart 5 is you've you know, a particular data set for the and method of calculation for the growth rate, and you know, I don't see why you couldn't do that for the other metrics that, you know, you define what your data set is and you have those numbers, and then you say, you know, my implementation of the CAPM, you know, this is how it compares with historical ROEs. Is there any reason that is not possible?
Well, it's possible. If you would like me to backcast my data going back to 2014, I could do that as an undertaking or as a bench request.
Yeah, I'm not making that request at this point. I'm just asking about you know, the theoretical possibility of, you know, doing a similar test on some of the other models that you did on the DCF model in chart 5.
Sure. I can do it. It's not impossible to do it. The issue is that while the inputs to the DCF are relatively straightforward, the other ones are not, and there would be considerable controversy between witnesses and interveners based on that. So I mean, I don't. And then if you're looking at it, you'll probably see the convergence. I mean, if you look at chart 5, you'll probably see some models up over top, the DCF on the bottom, and then the authorized return in the middle, which just shows that commissions are using multiple models to determine their ROE. They may weight DCF more, like this commission historically has, but there could be, but that's the way that analysts and experts go into their determination of the cost of capital. They take a look at all the relevant information that they deem it relevant, and then they come up with a range and a recommendation based on that. So,
okay.
I don't know how else to say it, but it's more use relevant models, and you will get to a reasonable return.
Okay, so on page 52, you assert that the commission has relied exclusively on a specific form of the constant growth DCF approach, and I understand that means sort of a final step where you would take the midpoint proxy group mean and the mean high results and average those together. So to rely exclusively would mean that the commission applies this method without fail, regardless of the circumstances. Is that correct?
That is what I testified to. I do not think that you as a commissioner or the New Mexico Commission is bound by that. But historically, since that case, that is the DCF model that the commission has relied upon.
Well, there has been a more recent adjudicated rate case with El Paso Electric. Are you aware whether that method was used in that particular case?
If I'm not mistaken, I think that the commission's DCF came out to around 9%, but I wasn't a part of the case. So I don't know for certain what it was, but I don't know. I don't know for sure, but I from what I recollect is that DCF was close to 9 at that point.
Right, but I'm specifically asking if that approach, which you've said the commission relies exclusively on, was used. I do not think so, but that's something that we can fact check.
Yeah, and I didn't read the order, so I don't know for sure either, but I know that around that time DCFs were lower than they are now.
That same case that you're citing for that New Mexico approach, I think you might have called it. It talks about that one reason for applying that method is because SPS at the time had a pending rating agency downgrade, and that therefore some upward adjustment to ROE was warranted. Wouldn't that seem to indicate that this method has been applied where circumstances warrant?
I think you're right, and I want to say that I addressed that in responding to Mr. Walters' testimony, because he brought up the same thing, that the company was in distress at the time, and that was the reason why they took the midpoint of the high and the mean growth rates. But I would like to point out that the mean result of the New Mexico DCF at this time is 9.55, which is 5 basis points higher than what the companies agreed to, or the signatories agreed to in this case. So even if you just use the mean, the historically relied upon DCF model by the commission would justify a higher rate of return than what was agreed to by the parties.
Well, I'm not sure that I would use that specific implementation of the growth DCF or think that it's appropriate here. There was another precedent in that case, 17-00255 UT. And, while we're on the subject of what the commission has done in the past, I just wanted to read out, or perhaps Examiner Hurst could put this up on the screen, that 17-00255 case recommended decision. Or I can simply read from it. That's
what page, sir?
Of the PDF, this would be page 89. So the headline there is the constant growth DCF method should be used to determine SPS's authorized ROE. And I'll just read it out quickly since it's pretty small on my screen anyway. In contested rate cases involving PNM, EPE, and SPS, witnesses consistently calculate ROE using multiple models, including the DCF, CAPM, and risk premium models. This case is no different. Each of these methods was used by ROE witnesses. However, in recent contested investor-owned utility rate cases, the commission rejected ROE analyses that combined the result of multiple methods, finding that it should continue its primary reliance on the constant growth DCF method. And then it continues to say, the DCF method is firmly established as the standard method of measuring the cost of capital in the vast majority of corporate finance and investment textbooks and is deeply entrenched in regulatory practice. So I just wanted to ask you, Mr. Diacenis, if you were aware of that precedent.
I am aware that the commission relies upon the constant growth DCF model for their decisions.
And does your ROE analysis combine the results of multiple methods?
It well, I mean, what we're here for is settlement. So the settlement and the agreed upon settlement is a package, which is not based on any models. So I mean, at this point, my analysis to the ROE shouldn't apply. But yes, I do look at multiple models and then make my decisions and recommendations based on the multiple models. And the use of multiple models is also deeply entrenched in regulatory practice and is also the standard of measuring the cost of capital using multiple methods. So I mean, I don't agree with the commission using and exclusively using a constant growth DCF model to determine their ROE in the case, but it's the commission's prerogative to do so. But there is substantial academic literature that says to use multiple models to determine the ROE. And in fact, every single witness in this case used multiple models to determine their recommendation on ROE.
No question about that. However, isn't there a difference between using different models to inform your results and inform your judgment and combining the results in a mathematical way to, getting the average of, the results of many different types of models? Isn't that quite different than simply using different techniques to inform your judgment?
So I developed a range based on my model results. And the midpoint of that range is what it is. It's not based on any one model. It's based on the culmination of all of my studies. So combining averages, medians, etc. I mean, that's how you come to when you look at a string of data and you try and make sense of that data, you're going to look at where they converge. And when you look at my results and you see that the constant growth DCF is by far the lowest out of all the models I use, you could see that maybe one thing isn't like the other. When you have four results and one's 200 basis points less than the next lowest one, it shows you use your informed judgment to see where your range should be within those data.
So, let's talk a bit more about, the assumptions that are going into these risk premium models, such as the CAPM and the other risk premium approach. So on page 70, table 4, you have a table with your summary calculations and your average equity risk premium estimate of about 9.2%. Is that correct?
That's right, sir.
So this equity risk premium, is it fair to say that it's quite widely studied in finance because of its importance?
Yes, sir.
So there are peer-reviewed papers. There are companies that publish their estimates. There are surveys of market observers and participants. You could have used these estimates. So I'm wondering, why did you choose not to? What is wrong with the equity risk premium estimations that are in the literature?
Sure. First of all, when you talk about, and I'm assuming you're referring to Dr. Woolridge's testimony, but I don't know who you're referring to in these different sources. But there are, when you look at the academic literature, you will not see, when you're determining an equity risk premium, either a market risk premium, an equity risk premium, expected market returns, you will not see those academic articles say use surveys, use expected returns from investment houses. I do have, and I have for sure responded to the inapplicability of surveys, market expected returns on the market from investment houses in my rebuttal testimony. And that's why I didn't use it. So while there may be articles that say, here is an equity risk premium, it's usually not timely. And the ones that are timely are surveys, and surveys aren't to be trusted based on other academic literature. Now, when you're talking about expected returns from market participants, those services and those documents are made for different purposes. Those purposes are them guessing whether or not, or they're guessing what level of return is going to happen, not the level of return that the investor will put their money down. So when you're talking about market expected returns, they are just providing a decision point. They are saying the market is going to return, and we think the market is going to return X. If the investor says, I think it's going to return Y, if Y is higher than X, they will not put their money down. So when you talk about investment houses, expected rate of return, any type of expected rate of return, that is not applicable to cost of capital purposes because of that. It's a different use of that product. Now, when I'm going to have to, if you could bear with me for a second, I'll pull up what I have in my rebuttal testimony about surveys, but it's going to take a little bit because it was a 200-page document, but give me a second.
That's okay. I don't want to focus on surveys. I would like to bring up Professor Woolrich's exhibit JRW 6, page 5, if Examiner Hurst has that available.
And Dr. Woolrich did not rely on his CAPM in his testimony. Generally, he relies only on his DCF. So anything that he recommends regarding the CAPM, he didn't rely on or for his recommendation.
Well, I think he did compare the results of the dividend discount model and the CAPM, and they were actually quite close. So, it seems to me that he did consider the CAPM, but just went with the DCF number, which was slightly higher. And I'm sure I could find that in his testimony given a minute, but I'm quite sure he looked at both in coming up with that 9% rate.
So on page 69 of his direct testimony, this will show his table 9. He says, since I rely primarily on the DCF model and the results for the electric proxy group, I'm using an ROE of 9 for the company. So when he relies on the DCF on his utility electric proxy group.
Right, but
so then that means that he discounts and dismisses his CAPM analysis.
I don't think so. I mean, if you look at that table 9, he's giving you a CAPM of 8.7, which is very close to the DCF result of 9. And he just says, I'm going to go with the 9, but that doesn't mean that he didn't consider the CAPM. If it had come out wildly different, I think, he may have, that may have been some food for thought, but I think he definitely calculated and considered the CAPM. Otherwise, why put it in a table?
You could ask him the question, but from my interactions within his testimonies over the last decade and a half, he solely relies on his DCF method for his return recommendation.
Well, that's your opinion. I wanted to see if Examiner Hurst has that
Yes, sir.
up, or
What page of 6 did you want, sir?
let's see, I'm GRW 6, page 5.
Okay.
So I'm not seeing that on the screen right now.
Yeah, so all I see is your desktop.
Well, it says I'm sharing.
We're seeing a nice screw pine tree or mangrove, or I'm not quite sure what.
That is actually a walking tree in
Okay.
Peru. Well, let me see if I can try this again because. How about now?
Yes, thank you. Thank you. So, if we look at these, the ex ante model puzzle research there, we get a range of different estimates, and if we look at the more recent ones, they look like they're largely between 4 and 6%. Would you agree with that characterization?
Yes, and that's consistent with his testimony on page 68 of his rebuttal testimony. And then he says, I will use an expected market risk premium of 6%. I gave the most weight to the market risk premium estimates of Kroll, KPMG, the Fernandez survey, and Demoteran. Demoteran, it's DAMODARAN.
Thank you, sir.
Yep. So with that entire page, he only uses those 4 pieces of data. And I plotted every piece of that data in my rebuttal testimony. And like I said, the 9.5 as agreed to in this case is based on negotiation, not on any one model.
I understand that. I'm just trying to understand your original calculation of the cost of equity. So it seems like the 9% you calculated is a real outlier compared to the kind of numbers we're seeing here. Isn't that a fair statement?
Well, if you take into account that Dr. Woolridge doesn't use any of those except for the 6% ones from Kroll and Demoteran and KPMG, I wouldn't say that it's a real outlier. And like I said before, I rebutted the reasons why those 6% risk premiums are not applicable for cost of capital purposes. So, if we want to, I could go through my rebuttal testimony. We could talk about why I think Dr. Woolridge is incorrect in his studies, but it's already on the record.
Okay, and Professor Demoteran, I think, of New York University, is coming out somewhere around 5%, is it? Maybe 5.25. He does this, publishes this every month on his website. So, I would just call to attention, the difference between, these numbers, 5.25 or even 6, and, the 9.2 number that you calculated here. So
one thing is that on the 9.2 number, if you look on the next page, on page 71, I applied beta to that number. And that's 0.76. Multiplying that 0.76 by the 9. So I multiply it by the beta to make it proxy group specific. So then when I multiply the average beta by the market risk premium, 0.97. So I mean, the 9.17 isn't even applicable to what this piece of paper is talking about.
Well, I mean, the focus here is on the equity risk premium, and I do understand the formula and understand that beta is multiplied by the equity risk premium. What I'm trying to assess here is your estimate of the equity risk premium in comparison with what's out there in the literature and what's being published by some of these companies. Isn't it true that if we just take that risk premium of 9.2%, and let's say the risk-free rate today is about 3.8%, we're at about a 13% long-term equity growth rate?
So if you take the 9.2, and that's, like I said, that's not my testimony. If you take the 9.2 plus a 3.8, you have a 13% projected market return. It's not a growth rate. It's a projected market return. So if you look at 13%, if you look at a 13% projected market return, that is 100 basis points different than the average long-term average return on the market for the period 1926 to 2022.
So the return, that's what you invest in the stock market, and a 13% growth, your return is that, your investment is appreciating at 13% per year, correct?
Using your situation, yes. And like I said, it's comparable to historical experience. So if you put money in the market in any period, you would expect a 12% return on your money every year. Given the historical data from 1926 to 2022, your average return, the long-term average, if you put $1 in at 1926 and you had it for all the way to 2022, you would expect to earn 12% a year, because that's the average.
That's reflective of history, and I'll assume you're correct on your calculations, but is it necessarily reflective of what we can expect going forward?
Yes, I don't particularly use historical averages as expectational values, but there is a study from Campbell, and he worked for Social Security Administration, and he wrote an article that was published, and what he says is an expected return on a variable string of data can be best measured by the arithmetic mean return. So when you look at market returns, they have zero serial correlation. They are random. Returns on the market are random in nature. So Campbell argues and is published that the next value in a random string of data that is best measured by the arithmetic mean return. So
isn't that 13% return or growth rate, though, considerably higher than what I would say most market participants and observers are expecting going forward.
It is, but like I said, those companies are providing their products for a different purpose. They are not looking for the investor required return on the market. We are. Their nature is to be conservative, and if you look at any of their products, they have significant, to the point, significant limiting conditions to their analysis. And if you backcast their projections versus what actually happened in the next year, especially Demoterin, you will see a chronic underestimation of the return of the market return. So I mean, when you're talking about some of these things, and also if you do the same thing for the market surveys, the Fernandez survey, the Graham and Harvey survey, any survey, you will see chronic underestimation of actual returns in the next period. Like that's how it is, and that's why I don't use them. In addition to the academic literature says that they're not valuable pieces of information to calculate the market risk premium.
But I guess the issue here is that we're not really concerned with the next period growth rate. We're concerned with the indefinite growth rate. And what would you expect the US GDP to grow at as an indefinite rate of growth?
So, there's one thing I would want to say about one future period, one next future period versus infinite future periods. If you're using a random string of data, it extrapolates out. So if you're using one period, say if you're doing 2024, what would you use in 2025? The long-term average, right? So, and that's how the theory behind the CAPM is, because CAPM is a one-period model too, right? So when you're talking about indefinite versus next period, I mean the risk premium model and the CAPM model are both single period model. Now, as far as GDP growth is concerned, it frankly, in my opinion, and it is, if you look at GDP growth, if you look at GDP growth and market returns, and I think this is in my rebuttal testimony too, the GDP growth rate is uncorrelated with market returns. And since we're looking for investor required returns on the market, investor required returns on equity, the GDP growth rate has nothing to do with my projections or any projections on market returns. As far as GDP growth as affected in DCF models, it's also in my rebuttal testimony that utilities have outgrown GDP since 1947. So they have outgrown GDP for 80 years. So it doesn't apply to DCF either.
But can it be true that corporate earnings can grow at 13% annually indefinitely, not for 1 year or 80 years, but forever, and GDP grows at 4% forever? Isn't it mathematically true that at some point corporate earnings would be larger than GDP?
I have, please let me see. I definitely have it. Give me a second. So in response to Mr. Garrett, I made that calculation. It's going to take me a little bit to get there, but I did a study on the fastest growing segment of the US economy, and I think that was social services. And the time for that to get to 50% of total GDP took, I'm talking round numbers here, 400 years to get to 50%. And then to get to 100%, it was 4,000 years. Now, if you're going to think that just think about the changes in the world over the last 100 years, and think about the change. What do you think the changes are going to be in the next 5,000 years? And you'll get your answer of, well, mathematically, you're correct. It is not realistic to think that that's going to happen.
Well, and just observing that, a 13% growth rate means a doubling every 5.5 years. So it really is quite an astonishing rate of growth.
Well, like I said, it's not growth, it's market returns, right? And like I said before, in this rebuttal testimony, I have shown that GDP growth has nothing to do with market returns. And when you think of it when you think of market returns as what they are, returns instead of growth, you'll see that we're looking at two different things. And Dr. Woolridge does try to conflate the two in his testimony, but he's incorrect when it comes to the relationship between GDP growth and market returns.
So I guess, I'm, putting aside the GDP growth issue, I'm not sure I see the distinction between, when we calculate a cost of equity at 13% for the market, whether we're talking about 13% annual returns or whether we're saying that these companies are growing at 13%. I'm not sure I see the distinction.
Okay, I think I could help you there. So when you're thinking about total returns, and that's what we're looking for, we break that into income returns and capital appreciation, right? So in market DCFs or anything like that, the income returns are based on dividend yields. The capital appreciation return is proxied by the growth rates. So when you're looking at total return calculations, you have to look at it like that. It's not a traditional DCF model where long-term growth equals long-term growth. Long-term growth is a proxy for capital appreciation.
Okay, I think I see your point that the cost of equity could be thought of as capital appreciation as well as dividends, and that the capital appreciation might be considered the growth here. So your range, I guess, if we look back at that original chart that you had, table 1 on page 5.
Yes.
So you used this plus or minus 50 basis points on your range. Is that reflective of your degree of uncertainty around that cost of equity estimate?
That's a good word for it, Commissioner. It's one of those things where in 2020 and back when we're really kind of in the midst of COVID-19, I had 100 basis points on each side. So that's a good characterization, sir.
So would you say that you had a relatively high confidence in the estimate, and so had a lower range was warranted?
Yes, sir, as compared to the last case or other cases in the COVID-19 pandemic and or volatile circumstances.
Okay. You did testify in support of the stipulation. Does that indicate that your initial estimate of the cost of equity was too high?
No, sir, I don't think so. It's one of those things where the company negotiated with the signatories, and it's a package, and there's give and take between that. So maybe SPS got things that they wanted, and the other signatories got things that they wanted, and then they came to a 9.50 ROE. I don't particularly think that it's an indication of whether or not my estimate was too high. If this was a fully litigated case, I would continue to support my recommendation of 10.75 in this case. And there is a fair amount of data that shows that 1075 is the correct cost of equity in this case. So no, I don't. And then, like I said in my support testimony, the return or the agreed to return is within my analytical results. So if you look at my rebuttal testimony, Schedule 1, page 4. Okay. So you'll see on pages 4 and 5, my DCF results are in that range. Now, I think you and I went around about how I think that multiple models should be used in determining a cost of equity, especially in a fully litigated case. But if you see the mean equity cost rate using my traditional DCF and the mean cost rate for and I'll just say historical New Mexico DCF, I don't want to get into putting you into any type of box, but the average of those two is 950. So I mean, it is justified by my results that they are in the low end of my reasonable range. I do think that 1075 is the correct ROE, but to avoid litigious and further arguments on the record, I think it's a reasonable outcome for all of the stakeholders.
Would SPS agree to an ROE that is below its cost of equity?
I think it depends on whether or not they got certain. I mean, it's not just ROE when it comes to settlements. It's allowances, it's disallowances, it's rate design. It's a whole host of issues. And I wasn't in the room with the negotiations, but I think that they agreed to a package that was acceptable to them.
What is SPS's current allowed ROE?
I think there's some muddiness on this. I think that they settled for the purposes of Hale and Sagamore in 2020 at 935.
Right.
I wasn't involved going back, so I don't know if what the last fully litigated or fully settled that covered everything's authorized return is.
Right. Would you agree that at that 9.35% level that SPS is able to attract sufficient investment capital to invest in its business and has sufficient cash flow to support operations?
I don't raise capital for SPS, so that would have probably been better to address to Miss Martin. But I could, if I could point Your Honor to page 4 of my rebuttal testimony. If you just pop all the way up to page 4. Rotate it a little bit. But if you take a look at the parties that were in the 2020 case, changes in their model results, their average changes in their model results, you'll see that the indicated results of the other parties in this case that presented ROE witnesses, you'll see that the ROE has increased from that. We'll call it 935, even though it was for Hale and Sagamore, but we'll call it 935, and you'll see that 950 that was agreed to by the company is below the average change in each of those categories.
Well, I guess my question is, isn't it some empirical evidence that the current ROE is 9.35 and the world seems to be turning still, that the company seems to be operating and investing? Isn't that some empirical evidence that that 9.35 might not be a bad estimate of the cost of equity?
Well, it may have been in 2020, but the reason why we do these occasionally, these rate cases, is because the cost of equity changes over time, and usually because of that, new models are maybe not new models, but everybody runs their valuation models, whatever ones they think are relevant, and then they come up with recommendations based on those returns. And if you look at what we have from the interveners, you'll see that their ROEs, their model results, their indicated results on average was up substantially from the last case. So if the market is telling you that the ROE is now higher than what it was, it should be higher than what it was. So while the world's still turning, it's not an appropriate ROE at this time.
So let me ask about capital structure. I forget, you've got an attachment here, Mr. D'Ascendis, with the capital structure of some of the electric utility operating companies. Can you
Yes, sir.
remind
It
me
should.
where that is?
So it would be Schedule 1. So it's still on my rebuttal testimony. It'd be Schedule 1, page 2.
Okay, I guess I don't have the rebuttal testimony in front of me, but I
It'd
am
be-
seeing Schedule 2, page 5 of 5 of the direct testimony.
Yeah, so the schedule, so the rebuttal is an update. So that would have through
Schedule 1, page what, sir?
page 2, one more page. I am a violator of your
My
magnifying glass rule.
10.5.
Yes, I was listening yesterday and I started gritting my teeth already, anticipating that. Yeah, I'll remember. I will. I like getting everything on one page. Anyway, yes. So, Mr. Commissioner, this page 2 on Schedule 1 updates it for 2022. Schedule 2 in my direct is probably just through 2021. So we could run either way. It doesn't matter to me.
So I was criticized yesterday by Mr. Stewart for looking at the equity in the parent companies to comment on the equity in the operating companies. So I thought that we might want to look at the equity in the operating companies instead.
Sure. So that would be.
So, I have this Schedule 2 of your direct testimony.
Yeah. So that would, if Your Honor would go to page 3 of that Schedule 1 of my rebuttal, that's also, that would be the updated one.
Commissioner, do you want me to pull up the schedule that you have in front, or do you want me to pull up the updated version?
It really doesn't matter that much to me as long as it's the electric utility operating companies.
Yeah, that's fine. It's illustrated either way, so I'm fine with whatever you have in front of you, Mr. Commissioner.
So Schedule 2, what page, sir?
5.
5?
Yep.
Okay.
Okay, so in looking at the common equity, we see quite a range of 41% to 58%. Did you calculate an average?
I didn't, but obviously the data's there. So the reason why I did not, though, is generally when you're looking at capital structures and the reasonableness of capital structures, you're looking for one thing. At least in my view. I think Ms. Martin put it pretty well yesterday. But when you're looking to say either impute a capital structure other than actual, you would want to see whether or not the target company's capital structure is out of step with other operating companies. So when you look at the range here, this represents the range of comparable operating companies and how they're financed. So when you look at that, you see that the company is within the range of those comparable risk operating companies. Now, I didn't calculate whether or not it's at the top of the range. I didn't calculate whether it's in the bottom of the range. And obviously, SPS is at the bottom of that list, right? So I mean, it's one of those things where you have to look at it to make sure it's reasonable. Now, if the company came and at a 60% equity ratio, then there's one of two things that you can do. And the one thing is to do a leverage adjustment. And the second thing is to impute a capital structure. But since the company is within that range,
So
there's no need to do either of those things.
So certainly the request is in that range. However, just looking at the numbers, it seems to be towards the top of that range. And are all of these companies, operating companies listed here, to your knowledge, do they have investment grade ratings from the rating agencies?
I would assume that they do, because if not, I'll pump the brakes there. Give me a second. I'm gonna go into my work papers and I'll let you know for sure. Entergy New Orleans is not investment grade. And then there are a couple that aren't rated. But yeah, so Entergy New Orleans is not investment grade.
Okay, but most of them seem to be. So my question is, why is it that SPS really requires a equity that's at the top of the range? Why not something closer to midpoint?
Well, that's, I mean, when you're looking at capital structures, and I think, like I said, this might be better addressed by Ms. Martin. But when you're you would want to use actual capital structure, because if you do impute a capital structure that is different, either higher or lower, there's a mismatch on income and grossing up for taxes and things like that. So there's a mismatch. So usually and generally, and this is FERC's FERC, FERC's practice, that you use actual if you're issuing your own debt without guarantees, and you're within the range of comparable companies. So I don't, so I mean, when you're setting a capital structure, generally the proposition is to set it to actual unless they give you a reason not to. And this company, as far as the request and as it's falling within the range of the capital structure of the proxy group, not only these operating companies. Now, I think you pointed this out yesterday. Even though it would only be below, I think it was Idacor, it's still within the range of the holding companies as well. So no matter how you slice it, the company's capital structure is within the range set by your comparable group that has been accepted by most of the people in this.
I understand that it's within the range. I mean, that's good data, but frankly, I'm more interested in, what's the right number than is it in a certain range? Well,
I mean, the other thing that I would say is that these, and I did calculate the midpoint and the median or the average and the median, and it looks like the average is 50.66 and the median's 51.27.
I guess the point I wanted to make about your previous comment that we should set it at the actual, what the actual capital structure is. Isn't there a chicken or the egg situation here that whatever we set is what the company is going to adjust their capital structure to?
That would be a good question for Miss Martin, right? I don't raise the capital. I don't set the capital structure. So I don't know.
Right.
I don't know whether or not she's going to, whether or not the company is going to set the capital structure based on what is in this case. I do know that SPS is not only in New Mexico, it's in Texas. So you would also have to balance that. That's the only thing I would add. So that would be another consideration. I don't, like I said, I am not the person to ask on I guess, capital structure maintenance or reaction to capital structure based on authorized awards. But I do, and then I guess another consideration is that we were talking about the settlement. We're talking about it as a package. And like I said, I'm not somebody who could speak to this, but I would think that since it's a package, any change in the package from the commission would then bring everybody else back to the table.
I understand that. I'm trying to determine whether I like the package, to be honest. So, based on what Ms. Martin indicated yesterday, I did get the impression that Excel would look at our sort of imputed capital structure and adjust actuals to match what's imputed. And so I guess, I don't have a great sense of what dropping the equity percentage would do to cash flows, but I have put that request in.
Yes, I wouldn't be the one to ask.
Right. Well, I appreciate it, Mr. Diascendis. I think, those are the questions I had in mind.
Well, thank you. It was good talking to you.
Thank you.
Thank you, Commissioner. I think it's been, excuse me. It's been about an hour and 50 minutes. So I think it might be appropriate at this time to take a recess. And we'll take a recess until 3 o'clock, and we'll come back and see if there's any other questions for Mr. Diascendis. So we are recessed until 3. Okay. Well, looks like we're back from our afternoon recess. Just an update on scheduling. Unless there's any objection or the witnesses are unavailable, I'd like to begin tomorrow's session at 9 o'clock with AG witness Andrea Crane, to be followed by Sierra Club witness Debbie Glick. After the conclusion of their testimonies, we'll return to the SPS proposed order while we consider the other witness request and subject to an update from Mr. Gecko.
Yes, I can provide an update now. If that would be
Oh, absolutely. Go right ahead.
Yeah, I
Give Mr.
communicated with Dr. Woolridge, and he would be available starting at 12:30 on Friday till 2. I know
Don't
it's
know.
not perfect. Then we may have to start looking at some opportunities to.
He's not available at all tomorrow.
Let me pursue that right now. I think
Okay.
we've been going down the line, and that was originally a hard no. I think we had
Okay.
Tuesday, and then we had Friday morning. Let me check on tomorrow.
Okay.
Absolutely, I'll do that.
Okay, check on tomorrow. I don't know. I don't think that an hour and a half potentially is going to be enough time, sir. And I'd rather than, I think it would cause too much of a disruption and continuity of presentation of evidence to have him testify and then leave and then come back, 4 or 5 days later.
And if it was one day later, like if we, from watching the questioning thus far and the reference to his testimony and such, I thought maybe an hour and a half was problematic. It feels more like 2 to 3 hours. Would we be able to do an hour and a half tomorrow and then that slot on Friday? I'm just fishing for options.
If at all possible, I'd like to have at least a 2 or 3 hour block. Might not take that long, but there are definitely questions, and I want to make sure that the commission has all of the information that it needs to make the legally appropriate decision.
Absolutely.
So see what you can do. Do some horse trading, please.
I'll just invite everybody to the wedding, so everybody get your bags packed, and we are heading out.
That's very nice of you. Thank you. Okay, appreciate that. Okay, Well, then subject to, if, unless, Dr. Rolwich wants to appear first thing in the morning. Like I say, I'd like to see, Ms. Crane and then, Ms. Glick. Okay, well, let's go back to Mr. D'Ascendis, who's had a chance to rest. Hello there, Mr. D'Ascendis.
Hello, how are you?
How are you? I'm hanging in there. I don't have that many questions for you. And I think one of the big questions I wanted to ask, Commissioner Ellison has already discussed with you with regarding looking at actually all of the operating companies and not the holding companies. And I guess I did want to give you the opportunity, if you had anything further to say, other than it's in the other than the agreed upon stipulated ROE is within the range, or as you say in SPS Exhibit 19, your stipulation testimony on page 3, you're answering the question posed at line 6. In general, do you support SPS's decision to agree to the stipulated ROE? You begin your answer on line 7. Yes, I do. Although the stipulated ROE is below the lower bound of my recommended range. In other words, 10.55. I recognize the stipulation represents negotiations among the parties regarding several otherwise contested issues. Are you disappointed, Mr. D'Ascendis, in a 9.5 agreement?
Well, I mean, I'm not the company, right? So the company has to agree to the settlement. So I would assume that they're happy with the outcome of the negotiations. If they weren't, they would have litigated the case. But I don't know for sure. I mean, I think that the correct authorized return, and if it was fully litigated, I would support my 10.75 recommendation.
No, I just wondered, you seem to be a professional who is very confident in his recommendation, and a lot of work, a lot of effort put into 4 testimonies in this case, the 3 of which presumably involved a lot of effort and time on your part to advocate a position that basically is being put aside for a stipulation. And I just wondered whether or not that disappoints you as a professional witness and consultant.
It does not disappoint me. If there was a time, I wouldn't be in this business if I thought I was going to win. I guess there's a lot of tilting at windmills, but my beliefs are my beliefs, and my models are based in all of the academic literature and theory. So I mean, my thing is that if it comes to if everything comes to an outcome that is agreed upon by parties, I think we've done our job.
Okay. Well, going on further a bit here, and what I'm going to give you is the opportunity, if you have any other explanation for why the commission would accept the 4.5 and the in the proposed cost of capital in the stipulation, other than it was a result of negotiation of several issues in the case.
So, well, I guess what I won't know, because I don't know how the sausage is made, I guess, so to speak, on the give and take and the negotiations. If we're looking strictly at ROE, capital markets, and like I said, like I discussed with Commissioner Ellison, there is significant upward movement in the indicated results of not only my models, but the interveners models, which would indicate a significantly higher rate of return based on just the movement and the movement of those model results over that time period. I also discussed with Commissioner Ellison that if we were comparing authorized ROEs based on when interest rates were at this level the last time, indicated ROEs would be over 10%, and that's on page 56 of my rebuttal testimony. If you look at page 13 of my rebuttal testimony, on table 3, there's significant movements in 30-year Treasury bond yields, A-rated bond yields, and BBB rated or BAA rated bond yields, in excess of 60%, and in some cases double. All of these measures, not to mention the fact that inflation is still double the federal target, and the volatility of interest rates are still at historical highs. That all indicates higher cost of capital than what the company agreed to. So I mean, there are a lot of measures in I guess in addition to model results, just capital market conditions that are indicating higher costs of capital, lingering recessions, that brings into increased risk. When there's a recession, investors require higher returns to get their money off the sidelines than lower returns, even though the expected returns on the market would be lower. And that's why, like I was discussing with Commissioner Ellison, that's the decision point. There's an expectation of market returns. And if you don't like that market return that's expected, you keep your money on the sidelines. Required returns go up in times of higher risk. And by all accounts, there's a prediction of a possible recession, and you have to take, and those market models and the results of those models reflect that, and it shows that interest rate, or that the cost of capital is in excess significantly of what the company agreed to.
But again, in the context of what I believe you termed it to be, that basically the base case is set aside and the commission has this agreement in front of them. Again, I understand the litigated position of parties.
Yeah.
And that different experts have different opinions and different ways to evaluate things. But apparently, at least I believe for 12 of the 13 parties, and not all the parties litigated this issue, but and even the party that is opposing the stipulation, I don't believe litigated this issue. But parties came together and set aside whatever differences they had to come up with a settlement. And again, other than the standard, oh, it's part of settlement negotiations. I'm trying to understand justification for, and you know, I mean, I'll ask the other witnesses why they were willing to change from their proposed recommendations on RE to the commission. But I'm just trying to give you an opportunity, you know, for, you know, someone who had advocated quite a higher ROE, why you think it's appropriate for, I mean, the agreed upon ROE, again, for stipulation purposes, is like 125 point difference from what your recommendation was?
Yes, and I guess I misread your question. I didn't agree to the 950. The company did. So
absolutely.
Right. So I wouldn't know the answer to why they moved from 1075 to 950, and I wouldn't. I don't get a vote on whether or not to take it. So
You're not part of the negotiations.
No, absolutely not. So
Okay.
I don't know.
But you're supportive of their decision.
Yes, and that was the supportive testimony that
Okay.
that was about the support and some of the numbers that support that number.
Well, let me ask you the rest of your answer there on page 3 of your stipulation testimony. Continuing on line 9, I understand SPS has determined that the terms of the stipulation would likely be viewed by the rating agencies as constructive and equitable in the current regulatory environment. I understand and respect that determination. That's your testimony, sir?
That's right.
Does I understand and respect that determination mean that you agree with the SPS determination?
Well, I don't know all the puzzle pieces, so I don't know. So I mean, I didn't read the entirety of the stipulation. I don't know, like I said, where the sausage is made. So because they were able to come to an agreement based on what they needed to come to an agreement on to avoid, I guess, I mean, this is already a long hearing and things like that, but I mean, additional litigation and things like that. I understand and respect to avoid unnecessary cost of ratepayers that they made the agreement. I don't really have much else to say about that. I mean,
well, and that wasn't my question.
Yeah.
Yeah, that wasn't my question.
Yeah.
What my question is that in your testimony, you say that you understand that SPS has determined that the terms of the stipulation would likely be viewed by rating agencies as constructive and equitable in the current regulatory environment.
Right.
So I'm just asking you if you believe if the commission were to adopt the stipulation, whether or not you believe that's going to be, based on your knowledge and experience, viewed as constructive and equitable in the current regulatory environment.
Okay, now I get your question. Yeah, I would think that a 12 out of 13 party settlement with a commission approval would show stability in the regulatory environment, which is far and away the biggest piece of evaluation for the ratings of a utility company. So I would think that a close to uncontested, one missing party out of 13, they agree, and then the commission approves that, I think would show the constructive nature of the commission as presently constituted, and would lead to further, I guess, positive outcomes for the company. I don't know if that results in a upgrade or an outlook watch or anything like that, but I think it moves the ball down the field a little bit more.
Well, and that was going to be my next question. I mean, basically, I don't know if you had time to listen to Miss Martin's testimony yesterday, but there is a certain amount of skepticism on my part about hearing that a utility come in and say, well, if we don't get what we want, the sky is going to fall and we're going to get downgraded and whatever. When, as I pointed out yesterday, since the time of that downgrade, SPS, through a stipulated appeal agreement, got a higher ROE than was recommended, the commission authorized. I mean, it was a 9.56 in that 17,255. In 19,170, that was stipulated. The company chose to stipulate that case. And again, for the ROE, I think it was 9.45. That's what the company agreed to. Again, it was stipulated for specific purposes. So, 2238, that was a stipulation too. Right? So basically, perhaps with your understanding of your testimony here about the current regulatory market and constructive and equitable, when there's been a downgrade for whatever reasons, there seems to be a claim. A lot of it has to do with our regulatory environment. We got our downgrade, but yet 5 years have gone by, and SPS has pretty much gotten what it asked for, what it agreed to. Okay, let me put it in that terms. SPS has gotten exactly what it agreed to. How the commission, how any negative outlook in these rating agencies could be attributed to the commission when they've been supportive of giving SPS and the parties to these cases that have entered into these stipulations exactly what they're asked for. Thoughts?
I mean, it seems like you have accounted for the history since the downgrade correctly, right?
I hope so. I've tried to.
Right. I've never worked for a rating agency. I don't know how it all works out. It may be, I don't know. I really don't know on how they tick, how the rating agencies tick, why they haven't recognized the rate case history between SPS and the commission and the parties. I don't know why. I know that in my generally, New Mexico is not known as a constructive jurisdiction historically. I know that they have changed from a elected commission to an appointed commission, and their constructiveness will remain to be seen. But I know generally historically, they have been painted with that brush, and because they have been painted with that brush, it's hard to get that paint off. So I don't know whether or not it's anybody's fault that SPS has stayed downgraded. But I don't have any solutions or opinions one way or the other.
Well, I know, you testify on beginning on page 5, 6, 7, regarding that exact subject of your of SPS exhibit 19.
Yeah.
Regarding the regulatory environment, et cetera. And while I understand, Mr. DeSantis, that you don't work for rating agency, you do work for SPS. And it is SPS that comes in this case and basically says, under the testimony of financial integrity, well, if we don't get, what we asked for, we're liable to be downgraded. Or if we don't get, whatever in some time period, that's going to be negative regulatory lag or whatever. And I don't work for rating agencies either. I don't know what they think or when they think, or if they're even paying attention to all these things. I guess trying to be that, back in law school, they talked about that reasonable person. I don't know if even after decades, if I've necessarily ever found that reasonable person. Everybody has, some type of opinion that they have, and it's only logical that they're trying to advocate that opinion. But I sure would like some, to hear some testimony, about how things can change rather than just the same song all the time.
Well, I mean, in my direct testimony, I did address regulatory risk in my testimony, and that was considered in one of my business risk adjustments. There, like I said, the investors generally think of New Mexico as not as constructive as other jurisdictions historically. I do think investors and the market watch hearings and decisions and settlement. Probably some Moody's people watching us right now. But see, their opinions are based on what happens in these in these proceedings, whether or not, and this proceeding is more or less yes or no on a settlement agreement. I think that the package as presented would, and I agree with SPS that it would add to the constructiveness of the regulatory environment. I don't know whether or not that's enough to bring it up. I don't know if a fully litigated case is able to get it all the way up to wherever it was before. I have no idea. But I do think that markets, investors are watching, and I think that there is an interesting thing that happened to Excel last month, where there was a recommended decision by the hearing examiner up in Minnesota, recommended a 9.87%. I think a month later, there was an open meeting of the Minnesota Commission. That Minnesota Commission's open hearing agreed to a 9.25. And you would see that the market immediately reacted when it comes to their performance with other utility companies. They have underperformed the market by underperformed the XLF or the XLU. I'm sorry, XLU by approximately 8% since that open meeting in Minnesota. So, and then there was a number of
did they get downgraded?
They got a number of articles. I think it's under reconsideration right now. So I don't know what's going to end up happening there, but you could see that the market reacted, and RRA, Regulatory Research Associates, reacted. There's been other reactions in press. So I would say that people are watching. Whether or not they are going to act is another thing.
And I believe you're referring to case number 21-630, where there's an interim decision, but there's no final order filed yet, correct?
Yes, like I said, I think it's under reconsideration.
But that same commission in an earlier Excel case for their gas utility in April authorized a 9.57 ROE.
Yes, in the settlement.
Well, that's interesting.
Yes, I thought it was interesting too.
Do you think that since the last 3 SPS rate cases have been proposed to be settled by settlement, do you think perhaps then that's hindering the rating agencies from actually making an informed reevaluation of the situation, and that maybe the commission would be better off having litigated cases?
No, I don't think so. And there's a couple of reasons for that, right? The first is that when 12 out of 13 parties agree to something, it seems to have balanced the interests of the various stakeholders in the case. Doing something other than approving the settlement would be against, I would think, the majority, or I mean, the overwhelming majority of the stakeholders, and probably not in the public interest. And I think that investors and rating agencies and people that rate regulatory jurisdictions would find that as not constructive. So, and usually if you talk about rating agencies and the reasons why they rate jurisdictions the way that they do, it's stability and it's transparency. So if a company comes to an agreement with several or all of the parties and in their rate case, rejecting that settlement would be something that is not stable, not transparent. So I would say that I would think that it would do more harm than good, especially if the parties all came to a settlement.
All right, sir. I don't have any further questions. Mr. Stewart, do you have any redirect for your witness?
I do have a few questions.
Go ahead, sir. Hang on. I don't believe anybody else had any questions for Mr. Diascendis. No. Okay, go ahead, sir.
Mr. Diascendis, do you recall some questions about, I believe it was chart 5 on page 45 of your direct testimony?
Yes.
Can you explain to me what the purpose was for preparing that chart?
Sure. So the purposes of that chart 5 on page 45 of my direct testimony was to demonstrate that authorized returns on equity by utility commissions have to consider more than just the DCF in making their decisions. So it is more about using multiple models to arrive at a reasonable rate of return rather than the effectiveness of the DCF model.
Thank you. And Mr. Diascendis, do you recall some discussion of a rate case for El Paso Electric?
Yes.
And do you know whether that case was the result of a settlement or was it fully litigated?
It was fully litigated.
And as part of that, there was some discussion about the commission's use of the DCF model, correct?
Yes.
And did you perform a DCF calculation for purposes of coming up with your recommended ROE?
I did.
And did you update that for purposes of your rebuttal testimony?
I did.
And what were the results of your updated DCF in your rebuttal testimony?
So if you look at page 8 of my rebuttal testimony, you'll see that there are a couple DCF models, the culmination of which is the mean and high growth rate DCF, which is shown on the first row there, is 9.99%. And if you take a look at footnote 5, which is just right under there, my original DCF the DCF result, just using my usual method, is 944, which was an increase of 70 basis points from my direct testing. Likewise, the discounted cash flow model using the New Mexico style DCF was up almost 80 basis points from what it was in my direct.
Okay, thank you. And the stipulation contains an ROE of stated ROE of 9.5, correct?
Yes, sir.
Is that stipulated ROE based on any particular methodology?
No.
Mr. Diacenis, there's also some questions about regarding the 9.35 ROE in the last stipulated rate case. Do you recall those questions?
Yes.
And if you know, was that stipulated ROE for all purposes?
It was not. It was for cost recovery on Hale and Sagamore wind plants.
And can you just generally describe to me what has happened to the capital markets and the cost of equity since the time of that last settlement?
Sure. So the settlement, now I have that in my rebuttal testimony, and like I was discussing with Commissioner Ellison and Your Honor, there has been a lot of changes in capital market conditions and model results from that case to this case. So again, on page 4 of my rebuttal testimony, all of the intervener witnesses that were common to this case, 1 more up, 3 more up. There they are. All of the interveners that were common to the last case to this case have had increased indicated ROE models. My models increased, and it's based on significant increases in interest rates, inflation, and beta calculations. So well, not beta calculations.
Wait a second, Mr. Diacenis, where's Dr. Woolridge?
Dr. Woolridge wasn't in last case. That's why I said interveners common to the last case. Mr. Kale was the AG's witness in the last case. So I couldn't compare his results to the results in the last case.
Okay, so you specifically compared witness, not necessarily party.
Yes, because Dr. Woolridge and Mr. Kale apply their DCF models and other models differently.
Okay, thank you. Go ahead, Mr. Stewart.
Can you spell Kale?
K-A-H-A-L.
Thank you.
Yep. So like I said, the increases in these results are from changes in market conditions, significant upward changes in market conditions. Like I said, interest rates, inflation, interest rate volatility are all up, and they're all driving these results. And that is why the ROE is higher now than that.
Thank you. And just changing over to your direct testimony and the schedule 2, that page 5 of 5. Do you recall some questions about that? That was the the capital structures of the various electric utilities.
Yes, sir.
Madam Hearing Examiner, any chance we could pull that up?
Tell me the page again, sir.
It is, I believe it's PDF page 122.
Is that it?
Yes, thank you very much. Mr. Diacentis, do you have an opinion as to whether an appropriate capital structure needs to take into consideration company-specific factors?
Yes, it does, and it's all about time. It's all about timing and availability capital. So, as you can see, a lot of these companies, well, all of the companies have different capital structures, and that's based on capital needs and capital availability. So, because of that, you can't fit one company into a box with a bunch of other companies, and that's why you should always use actual capital structures, or if applicable, if you can, if it's not outside the realm of possibility, use that capital structure, because that is how they were able to finance their capital projects with the capital available at that time.
And looking at this chart, can you tell me what the minimum common equity percentage is for the companies listed here?
41%.
And can you tell me which company has that minimum equity percentage?
AEP Texas.
Do you happen to know whether or not they're a vertically integrated utility?
They are not. They are transmission distribution only, and yeah, that's right. They're transmission distribution only.
All right. And Mr. Diacentis, do you recall some questions with hearing examiner Hurst about and some discussion about the various parties' position on the stipulation?
Sure.
And do you know how many parties oppose the stipulation?
One.
And do you know if that party opposes the ROE or capital structure portions of the stipulation?
They didn't provide a witness to provide cost of capital analysis, so I don't know whether or not their position is towards this part of the settlement.
Is it your understanding that they oppose the entirety of the stipulation, or some other limited portion of the stipulation?
From what I gather, would be a limited portion.
Thank you, Madam Hearing Examiner. No further questions.
Very well. Anyone have any questions in addition for Mr. Diacentis based on the commissioner's questions, my questions, or the redirect? Hearing none, Mr. Diacentis, thank you, sir. You are excused.
It's good to see you again. Have a good day.
Thank you. Same to you, sir. Just need you to exit the YouTube.
All righty. Bye.
Okay, goodbye. All right. I believe next in line, SPS has witnessed Mr. Moeller. Is that correct, Mr. Stewart?
Yes, I believe that's correct. And Mr. Moss is going to be presenting Mr. Moeller.
Okay. Will either of you be able to provide me with an update on my my bench requests?
Yes, we will have an update on that by the end of the day today.
Okay. And I'd also like to announce to SPS that upon review, I do not have any questions, nor do I believe that the commission has questions subject to recall for Mr. Watson or for Mr. Remington.
Okay, thank you, Your Honor.
So we'll need to stipulate in that testimony.
Okay,
Okay.
we will do that.
All right, sir. Go ahead.
All right, this time, Your Honor, SPS calls Mark Moeller.
I don't see him in the,
We'll check
in
on
the
that.
please admit me box.
I apologize, Your Honor. Let's see if we can, maybe there's a glitch here somewhere. He should be joining now.
There he is. Hello there. You've got your mute on. Mr. Lee, could you please swear a witness, sir?
Mr. Mueller, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter of opinion should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
Go ahead, Mr. Moss.
Thank you, Your Honor. Mr. Mueller, do you have in front of you what has been marked as Exhibit SPS 24?
I do.
Before we do that, can you state your name for the record?
Mark P. Moeller, Moeller.
All right, and by whom are you employed?
I am employed by Xcel Energy Services, which is the service company subsidiary of Xcel Energy, Inc.
All right, let's go back to SPS Exhibit 24. Can you identify that for the record?
It is my direct testimony in this case.
Okay. Was that testimony and its attachments, were they prepared by you or under your direct supervision?
They were.
All right. If you were asked the same questions today, would your answers be the same?
They would.
And are those answers true and correct to the best of your knowledge?
They are.
Your Honor, at this time I move for admission of SPS Exhibit 24.
Mr. Mueller, good afternoon.
Good afternoon, Hearing Examiner Hurst.
And I'm sorry, I did not catch, did you have exhibits to your
I did.
direct testimony? Okay, and they were prepared by you or under your direction and control?
They were. One thing I will qualify, the one thing I would change is I did file supplemental. So the numbers that are provided in my supplemental would be different than what I filed in my direct.
Okay. And that document, SPS Exhibit 24, a document of 219 pages, was placed into the Dropbox. Correct, Mr. Moss?
Yes, Your Honor.
Okay. Any objection to what's been identified as SPS Exhibit 24? Mr. Mueller's direct testimony. Hearing no objection, Exhibit 24 is admitted.
Thank you, Your
Sir?
Honor. Mr. Mueller, do you have in front of you what has been marked as SPS Exhibit 25?
I do.
Can you identify that for the record?
This is the supplemental testimony that I provided to my direct.
Does it contain attachments to it?
It does.
And were the testimony and attachments prepared by you or under your direct supervision and control?
They were.
All right. If you were asked the same answers today, or the same questions today, would your answers be the same?
They would be.
And are those answers true and correct to the best of your knowledge?
They are.
Your Honor, at this time I move for admission of SPS Exhibit 25.
Any objection as to what's been identified as SPS Exhibit 25? The 144-page supplemental testimony of Mr. Mueller as identified by him and placed into the Dropbox. I just want to clarify, Mr. Mueller, the attachments contain yellow highlighting. Is that to indicate that what does that indicate?
I believe it's just to more clearly identify the New Mexico portion of the costs as opposed to the total company. And then I don't know for sure, but I believe it is yellow indicates updated on 3/27, which would be the date of the supplemental. So it's
Okay,
more
and that
to
was the
just
da-
call out the numbers that changed.
And that was when the date that SPS filed its corrections to its application, correct?
That's correct. That's correct.
Okay, and in particular, I was looking at your 5 supplemental, page 11 of 29, and what's highlighted in column H is referred to as additions to plant and service future test year New Mexico retail.
Yes, that is what I am seeing as well.
Okay, and that's indicated as either corrections or specifying New Mexico numbers, correct?
Yes, the correction was in the New Mexico jurisdictional allocation. So the only numbers that changed as a result of that related to these schedules were the New Mexico split within certain functional classifications.
Okay, very well. Any objection to what's been identified by Mr. Mueller as his supplemental testimony as provided in the Dropbox, 144 pages, as verified by him here today? Hearing no objection, SPS Exhibit 25 is admitted.
Thank you, Your Honor. Mr. Mueller, do you have in front of you what has been marked as SPS Exhibit 26?
I do.
Can you identify that document for the record?
Yes, this is my rebuttal testimony as filed in this rate case.
Okay. Does it have any attachments?
It does have one. Yes, it does have an attachment.
Were the testimony and attachments prepared by you or under your direct supervision and control?
They were.
If you were asked the same questions that are contained within this testimony today, would your answers be the same?
They would be.
And are those answers true and correct to the best of your knowledge?
They are.
Your Honor, I've moved for admission of SPS Exhibit 26.
Mr. Mueller, SPS Exhibit 26 is your rebuttal testimony containing 2 attachments. A document of 25 pages put into the Dropbox. Is there any objection to SPS Exhibit 26, Mr. Mueller's rebuttal testimony? Hearing no objection, SPS Exhibit 26 is admitted.
Thank you, Your Honor. Mr. Mueller, do you have in front of you what has been marked as SPS Exhibit 27?
I do.
Can you identify that document for the record?
Yes, this is my testimony in support of the contested comprehensive stipulation.
Was this testimony prepared by you or under your direct supervision and control?
It was.
If you were asked the same questions that are contained within this testimony today, would your answers be the same?
They would be.
Are those answers true and correct to the best of your knowledge?
They are.
Your Honor, at this time I move for admission of SPS Exhibit 27.
SPS Exhibit 27 is a 15-page document placed in the Dropbox by SPS of Mr. Muller's testimony in support of the stipulation. Are there any objections to SPS Exhibit 27? Hearing no objection, SPS Exhibit 27 is admitted.
Thank you, Your Honor. At this time, SPS tenders Mr. Mueller for questions by the commissioners and the hearing examiner. I do not believe anyone reserved time for Mr. Mueller.
And I think you are correct. I do not believe that anyone reserved time for Mr. Mueller either. I just need to find the right notebook. Mr. Mueller, I think in the next rate case, you need to take on some more responsibility and take a couple of these witnesses area so that we can cut down on these 26 witnesses. So I'll have less notebooks. What do you think?
I will pass that on to my leadership.
Or not? Maybe you think you have enough responsibility. You. I would take even a few of your 26 people.
Your Honor, I think Ms. Trammell is willing to testify more if she can get some of that money back for all of the referrals.
The witnesses that, yeah.
She can get some of that money back for all the referrals she did yesterday.
Uh-huh. Yeah, I think a comment was made that she was going to have to go to somebody else's house for dinner, I think. Okay, Mr. Mueller. It looks like, according to your testimony, you're actually employed by Excel, the parent company, and not SPS. Is that correct?
It's actually XL Energy Services, which is a subsidiary of the holding company. So those of us that do work across all of the operating companies are employed by XL Energy Services.
Okay, and for the record, can you just give a general description of all of the many things that you do under your responsibilities as the Director of Capital Asset Accounting?
Sure. So within my team, we have 4 main functions. We do all of the actual accounting, the monthly close the books and recording the records, all of our accounting records for our assets. So that would be things like depreciation, allocating support costs into all of the capital projects that we have going on, closing out those projects and getting them set up. I also have a policy team So there's a lot of determinations that need to occur over the course of a month or a year in terms of whether things meet the required accounting criteria to be capitalized. So I have a team that reviews all of those and make sure that we are compliant with capitalization policy as well as accounting standards and FERC requirements. We also do all of the unitization of property. So as new assets are built, we make sure that all of the appropriate property records are created for those as they're put into service. We also retire the assets and account for any sales or disposals of property that occur. We also have a regulatory function that does all of the planning and support for these rate cases, as well as forecasts and projections for the company. I also do all the tax functions, or within my team, there is a tax function that does accounts for all of the specialized tax treatments that are related to assets and ensures that when we're talking about rate base here, that not only are we accounting for the assets themselves, but any deferred taxes that offset that are also taken into account. And I would say finally, we are also heavily involved in the removal process. So we have a lot of removal obligations for our assets. So we do the removal studies that support our depreciation rates.
Like the one that was attached to Mr. Watson's testimony?
Yes, so there is a removal study that feeds into Mr. Watson's testimony. So he would roll that all up into the total depreciation rates. And then we utilize Mr. Watson's testimony and the rates to support what we track in our systems.
Well, maybe I misspoke. Maybe not. I was thinking actually of the depreciation study.
Oh, okay. I do
and
not.
Then there was
directly
a dismantling study. So
Yes.
do you look at all those numbers too?
We do. We're more of a coordinator on the dismantling study. So we work with our operations teams to pull together the base assumptions. In cases where we need a professional engineering firm, like Burns and McDonnell, they would help us in performing the estimates, what it's going to take to dismantle a power plant like Tolk at some point in the future.
But those particular costs aren't put in until actually when the plant's dismantled?
Well, we begin estimating them on the day we construct new assets. So when we put a new wind farm in service, we already have to estimate what it's going to cost us 30 years down the road to remove the concrete foundations of those wind farms, remove any underground cables, and then we build those into the depreciation rates. So we do our initial estimates of removal at time of in-service, and then we update those as we go through the life of the plant.
So you actually are collecting dismantling costs prior to the period of the asset being dismantled.
We are, and that's really intended to make sure that we're not ending up with intergenerational inequities on that if the wind farm is benefiting customers over the next 30 years, the cost of removal of that should be built into that same time period as a component of the cost.
But you're saying that those costs are updated on what kind of frequency?
We typically update, it varies a little by jurisdiction, but normally within 5 years. So we don't want them more than 5 years old to ensure that they're current. But at the same time, we're always looking at cost benefit. We don't want to be doing these every year because the studies are not inexpensive.
It It seems like to me that the one that I looked at was like a 2019 one.
That's
Does
the
that ring a
last one
bell
that-
with you?
It is. It's a 1898 and Burns, which is part of Burns and McDonnell. They did the last study.
So it's almost time for a new one.
It is. It is.
I wanted to get okay, where did you go? Well, I don't see him. I wanted to get his title correct, but I'll just have to go as I think I remember it. You're familiar with Mr. Davis?
Brian Davis.
Yes.
I am familiar with Brian Davis. Yes.
And my understanding is that Mr. Davis also has accounting responsibility, but that primarily my understanding of his testimony is that he testified regarding the manner of the accounting methods, but that other witnesses were going to testify to the reasonableness of the expenses and rate-based items. Is that your understanding?
Yeah, I think of Brian Davis's position more as holistically around, it could include how our revenue models work and recovery, riders, allocation of costs across jurisdictions. So it's kind of more of an umbrella function. And then I would be the one piece talking about depreciation and capital within that.
Well, and that's what I was trying to get to is, yeah, that he's more of the overall, here's the methods we use, but you and your group are the actual, we're doing the actual application of the policy to the expenses and revenues and assets and liabilities, correct?
Yeah, I think that's a good way to look at it is, you could look at it as a pyramid or even a matrix. Where when I was talking about removal studies, we would be aligning our costs with Brian Davis in terms of how that affects the entire company. But we would also be working with generation resources, our operations people that know our plants very well to make sure that we're getting the operations assumptions that they know. They know the operations, but they don't necessarily know all the accounting requirements on what we need to do to account for these properly. So it's maybe a little bit more of a network on where we each bring certain expertise to the table to get these numbers right.
And which of the other witnesses, if any, in this procedure are part of this team that you referred to?
Well, all of the capital witnesses within the operations areas. Mr. Lau, I think Mr. Lytle might provide some of it on the generation side. Renee is the transmission witness. We work with them in terms of, in the case of a a future test year like this, they would be the ones working to determine what types of work are going to occur over the test year. We then take all of that information and translate that into actual expenses that will show up in the test year.
Okay.
I didn't hit on all of them, but there are, I believe Adam Dietenberger is another one of the witnesses that is involved in the specific business areas. We work directly with Naomi Koch's team. So Naomi is a tax director. We do all of the tax support work for capital, but Naomi has tax responsibilities for the entire company. And so it's that network of expertise that we all rely on amongst each other.
Okay. And so your function is separate from Ms. Nemi's function?
It is, but we also work with her as we break out assets. So when you think about it, we break out all of the assets by function. So we have generation, we have transmission, we have distribution. All of those rolls differently into Ms. Nemi's revenue requirements model. So we want to make sure that we get those correct so that they get the right jurisdictional splits on them, because they will vary by function.
Okay. You've indicated in your testimony in support of this stipulation, SPS Exhibit 27, that you're providing testimony in support of various sections. You know, this is page 2, line 3 and 4. It says you provide support for section 1.5 of the stipulation, and those are the depreciation rates, correct?
Yes, I believe they are.
In Exhibit C to the stipulation.
Yes, I am flipping forward to page 4 where it refers to section 1.5.
Yeah, and then if you look on page 3 of the stipulation itself, it says depreciation rates are provided in Exhibit C. Did you create Exhibit C?
I don't have Exhibit C of the stipulation in front of me, but my team did create the depreciation schedules that are included within that.
Okay, it's entitled Settlement Depreciation Rates.
Is that within my testimony? Are you looking?
No, it's attachment C to the stipulation.
Okay, I don't have that in front of me, but
okay,
if
hang on,
if
just
it
a
is the
second.
depreciation rates, it would be.
There you go. See number 5?
I do.
So then if you zoom to Exhibit C, page 1 of 7, it says settlement depreciation rates.
Yes, those are yes, the rates that we agreed to with the adjustments to the lives of the plants.
Okay.
Yes,
So,
thank you.
in addition to supporting sections 1.5 and 1.6 regarding depreciation, you actually are supporting the Exhibit C.
Yes, that's correct. These are the updated depreciation rates by the change in life of Tolk, Cunningham, and Harrington. The decrease in life of Tolk, extension of, I believe, was extension on Cunningham and Harrington.
And just generally, Mr. Mueller, when the lifespan of a generation asset is changed either to shorten or extend the use of the generation asset, it affects the depreciation rates, correct?
That's correct.
And either if you shorten the life and it's going to be abandoned sooner, or part of it's going to be abandoned sooner, then the collection of the depreciation amount increases, correct?
That's correct.
And then if you're going to extend the life, then consequently, the collection of the depreciation is going to be reduced.
Yes, that's also correct.
Okay. So when we're looking at numbers 5 and 6 here of the stipulation, it says depreciation rates are provided in Exhibit C. Depreciation expense component of the 33 million revenue deficiency, or I guess another way to say $33 million revenue deficiency, you're referring to, in the first sentence of the second paragraph, the increase in New Mexico retail base rate revenue of $33 million, right?
Yes.
So one person's increase is one person's revenue deficiency, right?
Right, right.
Okay. All right. So basically this 5, the second sentence says, of that $33 million, 10.2 million is going to be depreciation expense component, correct?
Yes, that's correct. You're looking at line 11 on page 4 or 10 on page 4.
No, I'm actually still looking at the STIP. I can go back, sorry.
Oh, I'm sorry. I do have a copy of the stipulation. No.
Okay. Yeah, no, I'm looking at the STIP. Again, just trying to ask some questions on your area of responsibility for the stipulation. Okay. So see, when it comes to valuation time, you have to put down, oh, and I did Exhibit C too, because that's not in your testimony, right? Okay, so yeah, we're looking at this. So 10.2 million of that $33 million deficiency, or as we have decided, base rate increase of $33 million. So my question is, is that 10.2 only allocated to the enumerated items in that paragraph? Do you understand my question?
Yes, but Tolk is the largest component and Tolk is only $1 million as stated in the paragraph below.
So then,
so this is the cumulative adjustment as adjusted for the 3 items called out for the Tolk depreciation, the Nichols extension, and the Cunningham extension.
well, also Plan X, right?
Yes, correct.
Okay. So there's 4 things and they all total up to be 10.2. Correct?
Correct.
Okay. And then as item 6 says, the $1 million is specifically to reflect the reallocation of dismantling costs between Tolk and Tolk synchronous condensers, and those will live on, right?
Yes, that's correct. Because there was also the adjustment that I believe is on the within the schedule where additional assets were attributed from the Tolk generating units to the Tolk synchronous condenser, which then lowered the depreciation attributable to the because of the fact that they have a longer life.
Okay. So some of the costs that were going to be attributed to Tolk are now being attributed to the condensers.
That's correct. That's correct.
Okay. Any changes in any other depreciation rates pursuant to the stipulation as evidenced in Exhibit C, other than those 4 things?
The unit life changes and the allocation change. I cannot recall any, I'm not aware of any other changes that we have. I believe it is just the four generating sites and then the adjustment to the Tolk between the generation and synchronous condenser.
Okay, but you're not changing any other depreciation rates for any other asset?
Not from what was originally filed.
Okay. All right, so then we go on to 2 of the stipulation. And section 2 is on page 5. And
page 5 of my testimony or of the stipulation?
Of the stipulation. Okay. And it says the date, and so that's the change in the dates, correct?
Correct.
And that that part of the stipulation is being contested, correct? If you know.
You mean related to Tolk and the retirement date?
Yes.
Yes.
And within your assignment, do you do any financial analysis? Are you that witness that made the financial analysis of whether to extend or not extend, or is that Mr. Elsey?
That is Mr. Elsey. So once we get the 2028 date, we would then redetermine depreciation based on that. But Mr. Elsey does the modeling.
Okay. And with regard to section 3, Plant X Unit 1, Plant X Unit 2, and Cunningham Unit 1, that part of the stipulation says that the abandonment and retirement for those units will occur on or before December 31st. Is that correct?
That's correct.
And what your group has done is has put a cost for those plants to be abandoned and retired before the end of the year, correct?
Correct.
And if, for example, there was some reason to extend those, then all of those costs would have to be reevaluated, wouldn't they?
They would be. But they would be reevaluated as part of a hearing. We would not extend them without regulatory approval, since all of our depreciation rates are regulatorily approved.
Well, with the exception of being part of a bigger generation, what's the appropriate term? Family?
If you were talking about generation assets, is that what you're referring to?
Yeah, for something that's more than just one unit, what do you call it?
We would move from a unit to a station, and then stations to the overall steam generation function.
Okay, well, I'm just generally, if for example, you have wherever plant X is, you have plant X units 1 and 2, and previously you had 3, didn't you?
We did. Unit 3, I believe, was retired. I don't know exactly, but a few years ago, I believe it was.
But some of the things
somebody will correct me if I'm wrong, though. or how about subject to check on that one?
Okay, no, that's fine. Or 5 people, if it's me, they'll correct you, or more. No, I'm just trying to visualize this, and I know that there are certain costs that are shared among generation units when they occupy the same space, or whatever you call it. I'm calling it a family.
So we will have common assets and facilities that are part of that as well. So usually things like the office space, there might be common ash ponds and holding ponds for a site that would be considered common assets and not unit specific.
Okay, so in actuality then, I mean, if Plan X 1 and 2 are gone and Plan and 3 is already gone, is that whole site going to be raised?
It would be. We would then begin removal activities. So where we talked earlier about recognizing depreciation expense, we would have a removal reserve in place to cover the cost of that removal at when we actually do the dismantling.
Okay. Are there any other units where Cunningham 1 is located?
I don't know that one off the top of my head. I believe I don't remember if there are also gas units at Cunningham. But Mr. Lytle or Mr. Lau could probably answer that question.
Okay.
I know there are sites where we have both, where we have converted from coal to gas, but I don't recall at this point which sites also have gas facilities on them in addition to the coal.
Okay. And then you also say that you have responsibility for Section 4, which is Nichols Unit 1 and 2, and those service lives are being extended to 2028 and 2027, correct?
That's correct.
Are there any other units there?
I don't know the answer on that one.
Okay. And then finally, on your testimony, you indicate that you're responsible for number 5, section 5 of the stipulation, and we've talked a bit about that already, about the depreciation rates. Although under the stipulation section 5, it says use of the rates in Exhibit C results in approximately 6.9 New Mexico retail decrease in the depreciation expense from SPS's rebuttal revenue deficiency. That's correct?
Yes, that's correct.
So potentially then that was one of the concessions that SPS made in negotiating the stipulation, correct?
Yes, that's correct.
And if I recall correctly, Mr. Mueller, you're an accountant, a CPA, and not an engineer, correct?
That's correct.
However, you work with engineers, right?
I do.
Okay. So you have to have a pretty good knowledge of the actual asset when you're placing a dollar value on that asset, right? And you have to understand what it does and what parts are composed of it, et cetera.
We do. Well, we work in conjunction with them. So to understand if, like in the case of a partial retirement, that we understand all the components that are being removed. So typically from operations, we will get a list of all of the components that will be taken out of service, will be dismantled if there are units that are remaining.
And do you actually have any responsibility for like negotiating or hiring the potential salvage, or I don't know if you give things away, the dismantling process?
We don't. We actually have a separate asset recovery team.
Okay.
That is involved on individual pieces of equipment. I believe in many cases, if we hire a third party to do the entire dismantling, that as part of that, the recovering salvageable parts is part of the removal process.
Well, it seems like in the testimony that, sadly, it doesn't sound like that, if I am recalling this correctly, that there's much of a salvage value for plants. So if you can't use the part somewhere else internally within the system, it doesn't sound like that you are going to get much of a salvage value for anything that gets dismantled.
It's typically scrap value for the metal components is the biggest portion of it. It's a smaller percentage for coal plants when we're doing the estimates for like wind structures. there's a lot more metal in a wind structure, so there's a higher salvage component. When we get the original dismantling studies, they calculate the cost to dismantle as well as the amount of salvageable product, and then what the market price is for that material. So it's all built into our expectations on what we should be getting to the extent possible for future scrap values as well as the dismantling cost.
Are you aware of like any secondary market for like wind turbine blades?
Wind turbine blades there isn't a secondary market. The challenge with wind turbine blades has been more about finding somebody that can take them, because the wind turbine blades are actually hardened to make them last longer. So there is an emerging market of companies that can basically tear them apart and either use them in some type of a salvageable method. But the intent is really to avoid putting them in a landfill.
Yeah, I seem to recall a conversation with a former commissioner who I had no idea that there was a landfill for broken wind turbine blades. And but it seems like I read something recently that there actually is a repurpose. And perhaps it's not reached the level of a market or or an actual viable alternative. Are you familiar with anything like that?
I know it's being explored. I had done some research when we were doing dismantling studies. And there is, can it be shredded and used in concrete, because there's fiber in it that can be used as a reinforcing material. The challenge is really breaking down the blades themselves.
Okay. So they don't have like, keep reading about all these catalytic converters that are being stolen, at least here in Santa Fe and New Mexico. The wind turbine blades don't have any metal that people are trying to get.
They don't.
Okay. And again, I understand. I just want your explanation for the record, because, like I say, you work with the people when you're putting a value to the generation parts and functions expenses. What's your understanding of I know the purpose for them, but what's your understanding and description of a synchronous condenser that you refer to on page 4 of your stipulation testimony, SPS Exhibit 27?
I would say I'm smarter than the average accountant when it comes to synchronous condensers, but much less smart than your average engineer.
Can you tell me what it is?
When I think of a synchronous condenser, it's basically you are taking an existing generator that used to generate power, and you are spinning it and using it to absorb reactive power and basically create stability within the grid by absorbing that and taking variability within the basically the sine wave that is alternating current and restabilizing it and ensuring that the grid stays stable by introducing that.
Okay. And I also wanted to look at page 6 of your stipulation testimony. And again, we're looking at items 5 and 6. Pardon me, section 1, 5, and 6. Let me back that up. Okay, there we are. Okay, so we're back to Exhibit C and the depreciation expenses. So on page 6, line 4 and 5 of your testimony, do section 1.5 and 1.6 violate any important regulatory principle or practice? You begin your answer, no. Those portions of the stipulation are consistent with existing regulatory principles and practices and do not require any exception from commission rule or practice. The depreciation rates are calculated so as not to violate any important regulatory principle or practice. That's your testimony, sir?
Yes, that's correct.
Okay, but my question to you is, they may have been calculated so as not to violate any important regulatory principle or practice, but are they accurate?
So I want to talk specifically about Tolk with the synchronous condenser. So I'd say there's some gray area when it comes to Tolk. We talked about the units that are being retired. We talked about the synchronous condenser, and we talked about common facilities. I'd say there's some gray area when it comes to some of those facilities. If we were just adding a synchronous condenser to a brand new site, we would not build the facilities that are required to support a large multi-unit coal facility. So the question was raised as we were going through this as to, we basically assumed that the common structures of the plant were really built to accommodate the coal generation operations of this plant. And the question was raised, well, what's the amount that's appropriately attributable to the synchronous condenser? And that's where I'd say it's gray. And where we did make the $2.8 million adjustment, and I believe it's the 1.1 million, to say it's supportable to say that these facilities will still support the synchronous condenser and therefore have a longer life, even though that may not have been their primary purpose when they were built. So when you said accurate, I wanted to make sure I added that context so you understand that there may not be a single right answer here, but there's a range of interpretation on how those common facilities could be allocated between the synchronous condenser and the coal units.
And will that picture become clearer with the abandonment of Tolk and the continuation of the coal part of Tolk and the continuation of the asynchronous or the synchronous condensers?
I think it will. My assumption is the common facilities will exist through the life of the synchronous condenser. That's what we're assuming in the way we've reallocated some of the costs between the coal units versus the condenser. But I'm not sure if it will become immediately clear or whether sometime after 2028, when all the coal operations are shut down, at that point, a determination might be made that some of the common facilities should be dismantled along with the coal units. Others may stay intact through the 2055 life of the, I believe it's 2055 life of the synchronous condenser.
Okay. Very well, sir. That I believe is all the questions that I had for you.
Okay. My apologies for the confusion between the stipulation itself and my testimony supporting it.
Not a problem. Any redirect?
Just a couple of questions, Your Honor, but would you be able to put the stipulation back up on the screen?
That I just took down?
Yes, I'm sorry, Your Honor.
Just give me a minute. I got some of my connectivity issues hang on just a second.
Or I can ask Mr. Mueller the question without the document if need
No,
be.
not a problem. It's I got my headphone issue fixed. I just don't have my Dropbox issue fixed. And so I have to pull this up from the commission's website and not the Dropbox, which I have on the laptop. That's why I was sort of chuckling yesterday with, it's like the thought of trying to work on two computers at the same time might be fun for some people. I'm not one of them. Okay. What page of the stipulation would you like, sir?
Page 7, Roman numeral 2.
Okay, there we are. You get to see the tree again. It was a really nice tree. I had no idea that it could actually walk when there was competition for sunshine. Okay, there you go, sir.
Thank you, Your Honor. Mr. Mueller, when you were discussing this page with the hearing examiner, I understood her to ask you whether section 2 was contested, and you said it was. Is there actually any opposition to retiring toll in 2028, or is it just how it's operated between now and then?
That's a good clarification. Nobody has taken exception to the calculations and the dates that I have here for 2028.
Okay. Now, hearing examiner also asked you some questions a couple of minutes ago about regulatory principles. Do you recall that?
I do.
What is one of the key regulatory principles as far as you're concerned when it comes to depreciation and depreciation rates?
You know, for me, it's the intergenerational aspects, or the recovering costs over the useful life. We talked a little bit about it when we discussed removal costs. But you know, it's also an issue that we're concerned about, is if we have a unit that's retiring in 2028, there have been some proposals, I believe they were in rebuttal, to recover those costs over a longer period of time. From an accounting function, we have to recover depreciation over the useful life of it. From a GAAP accounting perspective, we cannot, for accounting purposes, depreciate an asset that has 4 years of life left over 8 years.
Okay, and that leads to my question. Do the depreciation lives or the service lives and the depreciation rates that the parties have agreed on in this case comply with this regulatory principle of generational equity that you referred to?
They do. That was a key piece of it, was aligning the depreciable lives with the projected closure date of these plans.
Okay, thank you. That's all I have, Your Honor.
Thank you, sir.
Your Honor, when you're ready, I could talk to you about the bench requests after you release Mr. Mueller.
Okay. Any further questions based on my questions or the redirect for Mr. Mueller? I'm not seeing anybody. So thank you, Mr. Mueller. You're excused. And if you would just exit the Zoom.
Okay. Thank you.
Thank you. Okay. What would you like to discuss? The stipulated testimony at this point?
Your Honor, we could do that. I actually wanted to mention a couple of things. One was
Okay.
that Mr. Lau, you asked a few questions of Mr. Moeller about where these plants are co-located, like whether Plant X is with Toke and that sort of thing. He didn't know the answers to that. Mr. Lau or Mr. Laddle, either of them will know the answers about where these different plants are located
Okay.
and whether they are co-located together. In terms of
Okay.
the bench request, we will file all of those tomorrow morning, except one. There was a question to Ms. Martin yesterday about recalculating some credit metrics at 51% or 52% equity ratios. That one's going to take a little more time. Hopefully we can get it to you sometime today or at the latest on Friday, or tomorrow rather, or the latest on Friday. The others we will file first thing tomorrow morning.
Okay, very well. Thanks for that update.
I don't have the testimonies in front of me for Mr. Remington and Mr. Watson. Would it be okay with you if we stipulated those in tomorrow morning?
We can stipulate those in tomorrow morning. So as a plan for tomorrow, then we will be beginning with AG witness Ms. Crane, followed by Sierra Club witness Ms. Glick, and then unless Mr. Getko has an update for us, Dr. Woolrich is to be determined. And looks like the next witness in SPS's order after those witnesses would be Mr. Meeks.
Well, Mr. Meeks is out this week, Your Honor. He's going to have to be next week, so it'll be Mr. Miranda, and then we would continue down the list from there. Mr. Ripperger, Mr. Elsey, Mr. Lytle.
Okay. Okay. All right. Anybody have anything procedural that we need to discuss or any questions about our witness order for tomorrow?
Yeah, I have an update, Madam Hearing Examiner.
Okay, Mr. Getko.
I've obviously been communicating with Dr. Woolridge. Tomorrow is not a possibility, which
okay.
You know, we had proposed this before. It was a very short discussion between you and I about Friday morning, and my understanding was that the commissioners weren't available, but I do want to return to that simply because it is an option that he would be available for the entire morning on Friday, but we visited that either this morning or yesterday, and I was told that it wasn't a possibility. And so if we weren't able to do that, to get that multiple hour time slot that we want to reserve, then we're forced into a situation of looking towards next Wednesday and Thursday, on which he is completely available. And along with that, I'll simply, I do want you to know that when we pick our witnesses and such, we do that when the procedural orders come out, and we changed along the way on this case. And so that's part of the reason that we're having these difficulties. The wedding was scheduled long ago, but originally this hearing was going to happen on June 5th. So I'm doing my absolute best, and so is Mr. Woolridge. I spoke with him this afternoon.
And I appreciate that, Mr. Getko, appreciate your efforts. You know, I'll just note for the record that I wasn't the one that wanted to change the hearing. And you know, the request was made by the company for negotiation purposes, which ultimately I would think in their mind is successful as the parties, the 12 of the 13 have stipulated. So, well, I will do my best to see if there's any other thing that we can try to figure out. So he's not available at all tomorrow. And basically he would only be available from 12:30 to 2 on Friday. Is that right?
No, we have the addition, we already had that time of the morning on Friday from 9 until
Right.
12 Mountain Time.
My understanding is that's not going to work. So,
Yeah.
but so his availability is 12:30 to 2 on Friday, or we're going to have to flip to next Wednesday or Thursday, correct?
That's correct, Madam Hearing Examiner.
Okay. All right.
Excuse
We'll stay
me.
tuned.
Excuse me, Madam Hearing Examiner. This is Joshua Smith on behalf of Sierra Club. I'm sorry to interrupt, but I wanted to make sure to interject before we break.
Okay.
I have two questions. First, if it's not too much trouble and the other parties don't object, would it be at all possible to hear Ms. Glick first thing tomorrow morning rather than second? She has another engagement that she'd like to attend to. Obviously, she will make this a priority if need be, but that would be a request on our behalf.
I believe only one party CCAE reserved 20 minutes for Ms. Glick. And I believe there are going to be commission questions for Ms. Glick, as well as Ms. Crane. I have questions for Ms. Crane. So I just want to make sure that if it's at all possible that we get both witnesses complete before the lunch break.
Miss Crane is available for either order. And so if both were going to fit in the morning in the original order that you proposed, and Miss Crane has just confirmed with me that she has no problem with going second, just so you know that piece of information.
Okay. Like I say, I just have concerns that, if the commissioners have questions that need to be asked before noon, that they get the opportunity to do so. So I guess I don't have an issue having Ms. Glick go. But, she was supposed to be available and she's not going to be available next week. So I don't know if I really appreciate being squeezed on presenting the witnesses after I've already announced when the witnesses were going to appear. right?
I can appreciate that, and will abide by however you'd like to go. I
All
told
right.
her I would make a request.
Okay. I'll think about it, let you know.
One other quick thing, the second issue I
Sure.
want to raise again with you. We touched on this briefly at the outset on Tuesday, but the treatment of Sierra Club Exhibit 2,
Right.
which is marked SC-2, those confidential pages.
Yes.
At this point, I guess I'd appreciate your direction on this a little bit. We would like to have that information available in the record in the event that the commission disapproves this stipulation.
Well, and we talked about that on yesterday, and I had a discussion with Mr. Marks on the record about what had occurred in the prior rate case that I reviewed, and asked him whether or not that Sierra Club would be willing to withdraw it, and he said yes. So are you telling me you're changing your position now?
I am, your honor, and that's because the stipulation includes a provision that allows the other parties to withdraw from the stipulation should any part of it not be approved. And the information that's confidential, we believe, would be relevant and important to our case if certain parts of the stipulation were to be withdrawn, modified, or disapproved.
Okay. Okay, well, I did have that as an item to discuss. And if you're changing position, then I'll take that under consideration.
Okay. Thank you.
Okay, anything else procedural that we need to discuss? Seeing, hearing nothing, very well. We shall recess until 9 o'clock tomorrow morning. Thank you all very much. Have a nice evening.
Thank you.
Thank you.